YouTube, and then there we go. All right, welcome. I managed to get both streams running, the YouTube and the X stream. Thanks very much. If you're tuning in with me today, we have some motions to review in the Karen Reed case. And then also, if you did not miss the breaking news that just came in, that I can bring up on the screen right here. Where is it now? No, that's not the one I want. Is that it? No, that's not it either. I thought I had this window all set up earlier, and I said to myself, I'm ready for this. And then somehow the window with the news about the federal appeal just went missing. But that's okay. Nonetheless, we are not deterred. I shall bring up that window right now. And even though it thinks that it's up, it's actually only up on the intro screen. And which one is it? Is it that one? Let's see. Nope. I'm going to figure this out. So the breaking news, of course, is that Karen Reed lost her motion to stay her state criminal trial. She moved in federal court for that stay. So allow me to bring that up for you. There we go. And if you're just tuning in, this news literally just happened within the past 30 minutes, so you are seeing it here for the first time, and I will explain to you what it means in just 1 second. All right, there we go. So to make this a little bit less confusing, I'll get rid of that one. All right, so there you go. You can see that a minute order just issued from Chief Judge Dennis Taylor IV, and it was an electronic order with no memorandum of decision, which usually means you lost and it wasn't even close. And it reads, the defendant's motion for stay pending appeal, docket number 32, is denied. It entered 3/21/2025. Now, I was going to do a stream today to review Karen Reed's motion for a stay. It just went up, I think, yesterday or this afternoon, and it was denied like that. And this is a precursor, folks, a harbinger of Karen Reed's chances at the First Circuit Court of Appeals after losing in federal court last week or the week before. Now, I think it was last week. If you're wondering what's going on there, Karen had appealed the mistrial in her first trial, wherein jurors voted 8-4 guilty on count 2 or one of its lesser included offenses, which, by the way, Alan Jackson, count 2 is OUI manslaughter, and the 2 lesser included offenses are manslaughter and motor vehicle homicide, well, OUI. The jury reported a soft agreement of 8-4 or 9-3 guilty on count 2. And then there were all sorts of varying reports about whether the jury was deadlocked on other counts or acquitted Karen, although obviously they never voted in open court on that, or otherwise on the other counts. So Karen, notwithstanding this intense federal precedent, that also is embodied in Massachusetts case law dating back to 1831 pursuant to a case called Lawrence v. Stearns, Karen, in her infinite wisdom, paid $75,000 apparently to Marty Weinberg to try to challenge this precedent from Lawrence v. Stearns. That's the original case, which in Massachusetts says that agreements among jurors are not verdicts, that the only verdict that's considered legitimate is a verdict rendered in open court and affirmed by the jurors on a verdict slip. Now, Karen then ran into these other issues, this line of case law that starts with Tanner v. U.S. from 1985, which had to do with allegations that jurors were using drugs during deliberations in that case. The Supreme Court found in that case of the United States that even allegations of drug use among jurors wasn't enough to actually pierce the inviolability of juror deliberations. But then Karen runs into these other issues. I think one of the cases is Bluford v. Arkansas, wherein a juror, foreperson of the jury, actually stood up in court and said, we've acquitted the defendant on some charges, but then the jury went and continued deliberating and then either convicted or whatnot on one count, or there was a hung jury. And either way, the defendant appealed, and the Supreme Court said that even that foreperson announcing in open court, which definitely didn't happen in the Reed case, that there was an acquittal on some counts, wasn't enough for that defendant to get a retrial. And then the third case is Pena-Rodriguez v. Colorado from 2017, which had to do with an analysis of Tanner's general bar on piercing the inviolability of jury deliberations. And the court in Pena-Rodriguez found that there's a narrow exception for extraneous influence by way of invidious or allegations of invidious racial discrimination by jurors during deliberations. But we didn't have that in Karen's case. And in fact, the narrow scope of Pena-Rodriguez v. Colorado reflects the fact that there is a general, very firm, very strict, very high bar for attempting to pierce the inviolability of jury deliberations. This is true for a number of reasons. And therefore, Judge Saylor's decision on Karen's federal appeal of her first mistrial was always a foregone conclusion. Judge Saylor ended up writing a very nice, historically interwoven, which apparently Judge Saylor is known for, opinion denying Reed's federal appeal. Now, what Reed did, because her retrial is coming up as to John O'Keefe's death, jury impanelment is scheduled to start April 1st, and we have another motion hearing, I think, on March 25th in the lead up to jury impanelment. Reed wanted to delay the start of her trial, so she did two things. One, she appealed Judge Saylor's ruling to the First Circuit Court of Appeals. She was given a certificate of appealability, which is a very, very low standard, and Reed was then going up to the First Circuit, but during the pendency of that appeal, Reed wanted to delay the process for the start of her second trial, and so Judge Cannoni denied that request from Reed just a few days ago, and as a result, Reed tried to motion Judge Saylor for a stay of the lower court proceedings pending the resolution of the First Circuit Court of Appeals review of Judge Saylor's decision. And just minutes ago, Judge Saylor, in a very predictable fashion, denied post haste that request. So we are now full steam ahead, folks. If you're wondering what are the implications of that, we are full steam ahead to jury impanelment and actually the swearing in of jurors eventually for Karen Reed's retrial, which should start somewhere the second or third week of April in 2025. Now, it's important to note that we have 1,245 jurors or something in the pool for the first 3 weeks. There will be nothing broadcast, just the opening moments of each day, and then it will be a couple weeks of screening through these jurors. This will also, pursuant to the Chisholm case that just came down in the SJC, be one of the first times we'll see a third sheet on the juror questionnaire specifically related to asking questions jurors about extraneous or outside influence that they may have been exposed to related to the case. And listen, I'm really starting to wonder if it's even possible to find, with due diligence, 12 or 16 jurors, 12 jurors, 4 alternates, who could actually hear this case without having heard of it. I think the whole jury pool in this area is poisoned. So we may see other delays related to this case. But that was the news that just broke in the last hour. We have other news to discuss as well. But first of all, let me just reiterate, thanks very much if you're just joining. My name's Grant Smith Ellis. I'm a towel. It's coming up on 1:30 p.m. There is no Karen Reed trial motion hearings or anything going on today, and it is lunchtime during the court's updating of its docket. But there have been a flurry, I wouldn't say a flurry, but there have been a number of motions and rulings that have come down, both in the federal court and the state court, the Superior Court in Norfolk County, in particular related to Karen Reed's case and Aidan Kearney's cell phones and the admission of those cell phones that we also are going to talk about, although we did 6 hours yesterday previewing the immense implications of what that material on Aidan Kearney's cell phone and Lindsay Gattani's cell phone and Natalie's cell phone could mean for the consciousness of guilt play that Hank Brennan's going to make on pursuant to Commonwealth v. Mahoney, which is enumerated in the joint venture exception of the reporter's note to the Massachusetts consciousness of guilt instruction, and it explicitly lays out in very clear terms, I think, that case, what Hank Brennan is going for here overall. So Karen's just hopes are getting crushed in so many ways. She's lost at the federal level. Her stay was denied. Hank Brennan is just tearing her defense to pieces. The federal probe is confirmed is over. The evidence of from Karen's infotainment system, the telemetric data, is 8 gigs compared to 2.4 gigs from the first trial. And there's most certainly, along with evidence of Karen not actually breaking her taillight, of course, when she staged a bump into John's car around 5:08 a.m. on the morning of 1/29/2022. But there's also evidence at 12:31 a.m. or so, right before Karen backed her car up to roughly 24.2 or 24.5 miles an hour, decelerating to 23.7 miles an hour in a matter of milliseconds upon striking John O'Keefe and then leaving John to die on the lawn, and in turn, John succumbed to head injuries and blackening of his pancreas caused by hypothermia and died because of Karen's actions. But there's telemetric data that's going to show that John disconnected from the car right around 12:31 a.m. There's already data from John's phone showing that John's phone never moved from the spot on the lawn right where he was found, about 8 feet in from the road or so, after 12:31 a.m. And then people misinterpret all of this data, and I find it so ridiculous, although it's falling by the wayside. People used to say this piece of Apple Health data from 12:21 a.m. was indicative of John like going upstairs, when in reality, John and Karen didn't even pull up in front of Fairview Road until 12:24 a.m. And then Karen sat parked from 12:24, moved up at one point a little bit, but stayed there until 12:31, at which point that's when the moment happened when Karen backed up and allegedly hit John. But at 12:21, there was some Apple Health data showing John going up 30 feet and down 30 feet in 3 seconds or something. Very common for Apple Health data to show that when traveling on a road, which is exactly what Karen and John were doing on the ride over from the waterfall to 34 Fairview, which, and of course, Karen didn't arrive there till 12:24. But there's also data from John's phone connecting to Karen's telemetric data showing their path of travel. And then there's also data, as I mentioned, confirming that the strike at 5:08 a.m. later that morning definitely did not damage Karen's taillight. It was a bump at maybe 2 to 3 to 5 miles an hour, which even Karen's own experts from ARCA, who are themselves are going to be subject to another voir dire because of Karen's continual Rule 14 violations by way of withholding material conversations and payments between ARCA and the Reed defense until they were forced to be disclosed by the U.S. attorney, tipping Hank Brennan off through a TUI request that such communications had existed and were being withheld. But ARCA, the experts, even from ARCA, testified that Karen's taillight could not have been broken in a low-speed impact, such as the fake bump that Karen staged, I think, at 5:08 a.m. Now, that's just to dive into some of the more details here, kind of the more interesting details, rapid fire. There were 18 ring videos on John O'Keefe's home system between 12:37 a.m. when Karen arrived back at 1 Meadows Ave, John's house, after allegedly striking John at 12:31 and then driving back, which is about a 5 to 6 minute drive, driving back to Meadows Ave in Canton. Now, when Karen gets to Meadows Ave between 12:37 a.m. and 5:08 a.m., there are 18 ring videos that are recorded. However, only one of those ring videos was somehow not deleted. What was that one video? The video that Karen ends up trying to use to create reasonable doubt within her own case, where it looks like Karen backed up and bumped into John's car, even though it was clear, and in hindsight, it's now even more clear that there was no damage to Karen's taillight caused by that bump, and in fact, Karen's taillight was broken. Prior to 5:08 a.m., Karen broke her taillight clearly at 12:31 a.m. when driving backwards at 24.2 or 24.5 miles an hour, and then making contact with John O'Keefe, and then reducing to 23.7 miles an hour in a millisecond with a steering wheel turn correction indicative of a pedestrian strike. But okay. All of that was a little bit of a digression, because what I'm I was explaining why just the weight of the evidence and Hank Brennan's strategy and TurtleBoy's phone evidence and the consciousness of guilt and the telemetric data from the Lexus, it's all just combining in a way that's going to roll as if a Sisyphean boulder down a hill upon Karen and Alan Jackson's ill-fated Icarus-like asymptotic rise towards the perilous sun that is national and local media exposure, built on an artificial edifice of conspiracy theories and lies and smears and PR posturing instead of actual arguing the facts and the law. There's going to be a new saying in law schools: if you don't have the facts on your side, argue the law. If you don't have the law on your side, argue the facts. If you don't have the law or the facts on your side, pull a Karen Reed. Not in a good way. That is not a compliment. Yes, you can quote that. Let me pull up the YouTube comments. Sometimes, there are some people saying hello, and this is an impromptu stream, by the way, so I'm glad more people are saying hello on the YouTube. A lot of people watch on the Twitter or on the X, like thousands of people, and I'm thrilled that it's easier to watch that way, but I can't, it's hard for me to actually see your comments on Twitter because the comments pop up on the screen and then just go away, and it's hard to actually keep track. If you want to leave a comment, if you want to engage, if you want to, if you have questions, the best way to do that is on YouTube. It's just a much easier way for me to see the comments and engage with those questions. The only real rules are just no discriminatory comments and no derogatory comments, with an exception to the latter for what I call the Kate Peter exception. Hi, Grant, murdered by maestro. Help me get a link to your YouTube. Oh, that's great. Welcome, Cookie Ramlaw. Trevor McIntyre says, hi, Grant. I say hello. Rita says hello. Rita P says, hi, Grant. Trevor says, I'm really interested in the motion for attorney-client privilege. Oh, yep, we got that motion coming up. Thanks for the good news, Grant. Great channel, Grant. Thanks for all that you do. Thank you, Rita. Oh, Maui Swift is here. Wonderful. Glad to have our venerated, wonderful moderator with us who ensures that the no discrimination and no derogatory comments rules are upheld, with the exception to the latter for Kate Peter. What do you want? You're on inquiry notice. You have no choice. Yeah, I'm not talking to the moderator. I'm saying you're all on inquiry notice. Yay, things are finally turning around in favor of John and family. I agree. And then Lucy says, hey, Cookie. And then, of course, hello, Maui Swift. All right, now let's dive into what we came here for, which is, just give me 1 second, because obviously the denial of the federal appeal is important. But what we actually want to take a look at is this, isn't it? Yes, it is. So, allow us to do so together in our traditional towel style. All right, let me just drag this window over here, and then let me do that. Let me try to make the text a little bigger. 1 second, folks. How about that? Look at my excellent editing skills. Now we are able to parse the document and see the text no matter what size screen you may have. Okay, so this is a motion, and originally when this got docketed, I think a lot of people thought that Hank Brennan was going to invoke the crime fraud exception, because there's pretty clearly concerning evidence that, and we'll get into it a little bit later after we read this motion, that Aidan Kearney and Karen Reed and Karen Reed's lawyers were all talking. Potentially documents were being given. Actually, there's a record that documents were being given to Kearney that were under protective order and then released, and then Kearney's lawyers were referring to them, or excuse me, Karen's lawyers were referring to them in pleadings, which is literally like there's an explicit prohibition against document laundering that in that way in the ethical rules. But what's really interesting is a lot of people thought that this motion was going to be suggesting that Yannetti and TurtleBoy and Karen are somehow schemed to like commit some kind of crime, and we'll talk a little bit about why there's evidence that Kearney was saying things indicating he had been talking to Yannetti and Jackson. In fact, that there was a litany of calls, 29 or so 58 in total calls, 29 each between Jackson and Kearney and Yannetti and Kearney, and then there were 180 something calls, 190 or something calls between Karen and Aidan directly. We're talking between early April of 2023 and the December 20th of 2023 or so. And then those calls with Aidan totaled over 40 hours or so. Now, what's fascinating there is that although this is not the direction the motion went, the crime fraud exception, there's another exception to the attorney-client privilege rule, which, and now Hank Brennan, we're going to find out, is specifically asking for records of Karen Reed and Yannetti talking between January 29th, 2022, the day of John's death, when Yannetti was retained, and Karen's initial arraignment in Stoughton District Court on February 2nd, 2022. Now, if you look at the public statements Karen has made about what she said to Yannetti during that time, it's then clear, if you think even more deeply, about why Yannetti stood on the steps of Stoughton District Court after Karen's arraignment and was like, my client had no criminal intent. It was because, we're going to find out, Karen said on an ID Discovery documentary that Karen had spoken to Yannetti and talked about it on the documentary, saying she was concerned that she potentially had clipped John or hit his foot or ran him over or ran his foot over, and that she had caused his injuries and his eventual death. Yannetti told her there was some criminal liability there, and then Karen says that's what freaked her out. There is no privilege. We're going to hear from Hank Brennan. If Karen Reed goes on a radio show and says openly, it wasn't a radio show, it was a 5-part documentary on HBO Max and Investigation Discovery, but if Karen Reed goes on there and says, this is what I said to my lawyer, the privilege is not with the lawyer, it's with the client. And if the client goes and publicizes their statements, there's no privilege. And so, Yannetti can't claim a privilege for himself. He can only claim his clients. I mean, I guess he could claim work product, but it's not going to work because his client's the one who has the privilege. So, Commonwealth's motion to compel communications between the defendant and attorney Yannetti stored within the defendant's cell phone data. No, at least Hank Brennan's polite. Calls him attorney Yannetti. I'm going to eat some peanut M&Ms for sugar before we begin. All right. The Commonwealth seeks all text, emails, or written communications. Between the defendant, Karen Reed, and attorney David Yannetti, restricted to those communications that occurred between January 29, 2022, and February 2nd, 2022. Let us scroll down. Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Oh, wow. So they did actually get the cell phone, and they got the search warrant. And then there was a taint team, it seemed. Because of an observed attorney-client communication. Hold on. Let's pause. You want to see something fucked up? Hold on a second. Is it hiding there in the background? No? Okay. Where is it? Where is it? I literally just had the Google Chrome screen up. We're going to find it. All right, here we go. When this motion references this, okay, just want folks to take a little look at this email here and tell me if this isn't a little fucked up. Do you all see that? Do you all see that email? That is very clearly an email from Karen Reed on August 26, 2022 that says, writing to Alan Jackson, okay, thank you. Just please understand that I am summoning every possible resource to get to the $200K, which is what Jackson wanted for his fee. And I think that Yannetti is likely out of his league with what this case requires. I just can't have the relationship with him fall apart and resort to a public defender for trial. I also don't want to disclose our fee agreement with Yannetti since he's already given me a break on his trial fee, $200K versus $250, with $100K signed over from my bail money if we go to trial. I'm planning on saying that, if we go to trial, I don't think she was thinking about dismissal at that point. I think she was thinking about a plea. I'm planning on saying that a colleague is paying you directly, which is close to true. A colleague has structured a low-interest personal loan for me that is payable at maturity. And then, let me see if there's any more to the image. I think it's just, no, that's it. And then it says up at the top, Alan Jackson's reply is totally understand, we are good. So, folks, how interesting is this footnote? Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Because of an observed attorney-client communication, an observed? I found that on social media, but I have some ideas. An observed? The phone data was provided with the assent of the defense. So what happened was, somebody came across that, and then it was the right procedure. The Commonwealth alerted the defense, who said, okay, then we should have a taint team. To the Attorney General's office, and a court-ordered taint team protocol was implemented. There you go. The Commonwealth received the defendant's phone data with any privileged communications excised. Given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversations with Attorney Yannetti on January 29, 2022, and the following 3 days, the Commonwealth is entitled to the communications between the defendant and Attorney Yannetti for this waived narrow period of time. I tend to agree. This is a very strong argument from Brennan here, and let's take a look a little bit more at what Brennan's going to argue. The privilege holder, Karen Reed, has waived her attorney-client privilege with Attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29, 2022 through February 2, 2022. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. Yeah, Karen's her own worst enemy. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. Number two, to ensure that only the communications that were waived are provided, the Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone for the time between 1/29/2022 and 2/2/2022. What that means is Brennan is saying, to decide if you want to grant this motion, Your Honor, what you should first do is these messages are already screened by the taint team. Without, well, obviously the defense has them, but without the state getting them, Your Honor, Judge Kearney could, in camera, in private, inspect the documents, make a determination as to which documents fall within the purview of Mr. Brennan's request and which correspondences between Reed and Yannetti may have been subject to the publicity waiver enumerated in Brennan's statements just a few seconds ago in his motion. And then Judge Kearney would say, okay, these are the documents that are responsive. And obviously Judge Kearney would only do that if she's inclined to grant the motion. So keep a close eye as to whether this request for an in-camera inspection of the documents is granted, because it means Judge Kearney is leaning towards granting the motion, at least in part. All right. In support of this motion, the Commonwealth acknowledges and respects that the attorney-client privilege protects privileged communications. Privileged communications between a client and his or her attorney. Mass Rules of Evidence 523 provides that. Waiver of privilege. UCA waive. A privilege holder or the holder's legally appointed guardian, administrator, executor, or heirs can waive the privilege. Conduct constituting waiver. Except as provided in Section 524, privileged matter disclosed erroneously or without opportunity to claim privilege. A privilege is waived if the person upon whom this article confers a privilege against disclosure. Confers a privilege against disclosure, okay. 1. Voluntarily or consents to disclosure of any significant part of the privileged matter. That's written a little weird. The whole thing's written weird. 2. Introduces privileged communication as an element of a claim or defense. C. Conduct not constituting waiver. A person upon whom this article confers a privilege against disclosure does not waive the privilege if. Oh, so that's when they waive the privilege. This is when they do not. If the person merely testifies as to events which were a topic of privileged communication, that's not what we have here, there is an unintentional disclosure of a privileged communication and reasonable precautions were taken to prevent the disclosure. Neither of those apply. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with Attorney Yannetti regarding the collision between her vehicle and John O'Keefe. For example, in the defendant's recorded interview with Gretchen Voss on June 20th, 2023, transcript page 105, line 23, the defendant concedes, "You never said, 'Did I hit him?' I hit him, as I said." Question. You never said, "Did I hit him?" I hit him. That's a weird question. Answer. I said, did I hit him? And then, when I talked to David, sorry, and now this is later, David said, "Karen, if you incapacitated John in any way, there's culpability there." Capability there? Maybe Yannetti said capability. I think the word's culpability. And I thought, all right, maybe this is maybe I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? Attorney Yannetti, Attorney Jackson, and Attorney Little were in attendance along with the defendant and Ms. Voss. So, 1, there's no privilege for Karen saying that to Gretchen because Gretchen was there. And if a third party is there when you're talking to your lawyers, the privilege is waived for everything you say. And then the other thing is the double layer privilege, because within the interview, and I don't know if this has been made public, I forget how much of this was in Gretchen's article. Did Gretchen put in her article that David said, Karen, if you incapacitated him in any way, there's culpability there? Like, Karen's relaying David saying that to her. she's breaking the privilege to Gretchen. But did Gretchen just withhold this? Did she know this the whole time? So you got one. Gretchen gets approached in July of 2023 by Alan Jackson, and Jackson's like, I have documents I want you to cover, but you can't cover them because they're protected. But if Walsh's lawyer covers them first, then you, Alan Jackson, you, Gretchen Voss, can cover them as if they were referenced in the Walsh case, and I'll have some cover. I, Alan Jackson, will have cover for releasing them. First, that option happens. Now, whether Voss goes through with that or not, it seems like she didn't, but that, play happens. I don't think Voss ever says anything about this to anyone. And then that was apparently recorded in these transcripts, these recorded interviews. The state doesn't win the motion for those, I think, during the first trial. They got some of them from Gretchen without objecting, but then they win the second motion in the second trial, and now there are these transcripts that keep coming out of these recorded interviews about Gretchen and Karen talking, and Karen not only describing what she said to David Yannetti in the first days, but describing Yannetti saying to her, Karen, if you had incapacitated John in any way, there's culpability there. My God. And wait, wouldn't you put this in your article? Why was it? I have to reread Gretchen's piece, but if this isn't in there or in any piece that Gretchen wrote, if that line isn't in there, Karen, if you incapacitated him in any way, there's culpability there, attributed to David Yannetti by Karen Reed. What the fuck? Literally, how did that happen? What, are you right? Did you hold it on purpose or for some larger purpose? There's some weird shit going on with that whole timeline between Voss and Yannetti and Jackson. All right, let me read some comments. Let me pause for a second. Let's see. Oh, there's a lot of comments. All right, I got to scroll for a second. This is why I try to keep up with the comments, because otherwise I can't read them all. We talked about the Fed appeal. It's not the full Fed appeal. It was Karen's attempt to stay the lower court proceedings while the First Circuit contemplates her appeal, which is also going to be denied. Someone said, justice for John O'Keefe and his family. Lock Karen up and get the justice they deserve. Very good comment. That was from Judd Rops or Judrops. My King of Kings says, did you see Karen glare at Hank yesterday? There was something seriously wrong with that woman. Now that is one that I can bring up for you right on the screen. Let me see here. All right, let me just enlarge that a little bit. All right, and then let's take a look. Which one was that? Was it this one? Yeah. And then let's take a look at Karen's glare that is being referenced, because that is the peril of having a memory that just sees everything. All right, where's the glare? That's not the glare. We're not talking about the glarer. We're talking about Karen's glare at Hank Brennan. They had a stare down, is how I think I posited it, but it's going to take a second to get there because it was in. Oh, there it is.
Videos.
Look at Karen. That was when Karen came in the middle of the Aidan TurtleBoy Kearney motion hearing that Hank Brennan knocked out of the park and won. She's just staring at Hank Brennan. She hates Hank Brennan. She's outmatched by Hank Brennan and humiliated. Hank Brennan plays international politics. Karen plays schoolyard checkers and then has dreams of playing chess on the veranda at Chatham Bars Inn, but is never going to make it. All right, let me get rid of that for a second. All right, hold on. Okay, now we're going back to some of the comments, and we're going to dive back into the motion for the Yannetti and Reed contacts, which is, I think Brennan might win this. Okay, someone said they just subbed 5 more minutes before I went live, and then they had saw on X Hank Brennan won his motion. Yes, by the way, if you're just joining, I do a lot more content on Twitter than I do on YouTube. My Twitter is like 110 million impressions over 2 years or something. So there's way more viewers there, but it's harder to do comments. I would, if you want to subscribe on YouTube, that's great. It's youtube.com/Grant Smith Ellis is my channel, and you will find the video live. And if you like that video, I think while it's playing, and subscribe from the video, I think it does better for the video and the algorithm or something. I don't know. YouTube is a little bit new to me, but I welcome your subscriptions on YouTube. And then if you chat in the YouTube comment box, which is the more important point, I'll be able to see it, and I oftentimes read out the comments and things like that. And of course, this is a public information service. No super chats or anything like that. You don't have to send money to ask questions or send donations to ask questions or make comments. In fact, I don't think that is a healthy way to engage in discourse, but you can always send donations if you want to, and I appreciate them, and they help me stay alive. Okay, so no law tubers are covering it. Yeah, I think this was a bit of a bombshell day back to back. Someone said my King of Kings said they're glad they found another source. Yes, well, I'm glad you found the channel. Let's see. Amber Am says, if TB talks to KR's attorneys, then it's not privileged because they aren't his lawyers. Yep, and there's a lot of communications between them. Brilliant news today. Yep. I think Melanie says, I think Judge Kearney will deny it or err on the side of caution on appeal issues. Yeah, but there's a way for her to deny it in part and grant it in part. It's a very narrow set of communications, only between 129 and 22. And if there's case law, we'll try to shepherdize it. If there's case law, by the way, I'm not a lawyer, you're a lawyer, or anyone's lawyer, I'm a towel. Get a lawyer if you have questions about the law. Get a towel if you're striving to find unconditional love in a world that seems to resent that very concept, yet seems to also stare in awe when that type of unconditional love flows from concrete like a rose. Anyway, between 129 and 22 is such a narrow scope of material that I think that there's very narrow grounds to even challenge or appeal it, because it's not a very overbroad request. And as we're going to find out, the publicity that Karen was giving to these statements, even though it might, she was making them notorious, and it falls pretty squarely within when there's an exception to this privilege. And so the only thing that's holding Brennan back from getting these materials, which are already searched, so this isn't really a Lampron issue, because the materials were already searched and seized. It's a question of whether the taint team should be permitted to give material to Judge Kearney to review to see if it should go to Brennan. That's a much easier standard to meet for the prosecution than like a Lampron motion. They don't need to get the records. They already have them. What they're trying to do now, the state with this motion, is get permission for the taint team to release them. Let's see, what other questions? Someone said, hopefully Peggy, jumped all the way to the bottom there. Hopefully Peggy and the O'Keefes will get some justice for John. I agree. Grateful for Lucy R. says, grateful for Hank Brennan. He's brilliant. Yes, I think he could liberate Europe and save the free world from the rising BRICS threat to the American world order. And by God, Mr. Brennan, if you ever wish to do so, and I'm in the position to do so, I will appoint you as commander of the Allied Expeditionary Force in Europe. D said, I think Karen definitely intentionally bumped John's car in the driveway. If true, this shows intention, and knowing that she had hit John and thus trying to cover it up. Agree. Someone said Hank's, Dewdrop said Hank's on fire. Agree. Let's see. Dewdrop said it was disgusting what TurtleBoy said about Peggy and the O'Keefes and witnesses. I agree. Goldie Lawrence says, what did I miss? Just to get you caught up, we reviewed how Karen lost her attempt to stay the state court proceedings with a federal motion to Judge Saylor, who also denied Reed's federal appeal last week. So that means the state court jury impanelment and the state court process continues to move forward while Karen pursues her futile and ill-fated First Circuit appeal, which will get denied. Then Karen, while the state court trial is going, will pursue a petition for certiorari to the Supreme Court, and then that will get denied as well. Amber Ann says Hank is very brilliant. The jury's going to love him too. I agree. D says, I think Karen is going to plea. Yeah, I'm really thinking we're heading towards a plea, folks. Just everything all of my gut intuition, all of my analysis of the different posturings and the content of the motions and the legal arguments and the facts, I think we're moving towards a plea. Not like the last trial where I think a plea was on the table at one point, but then the defense didn't feel cornered to the point where the deal offered was good enough. Now, I think if Brennan even offered like 3 to 6 for Reed on OUI manslaughter, that one would be tough because of the license suspension. But I think if he offered 3 to 6 in state prison on manslaughter, and I think you can do that because it's 2.5 to 20. It's actually up to 2.5 or 2.5 to 20 or something on manslaughter. A 3 to 6 cap, limited right of appeal if Judge Cannoni goes over the sentence recommendation. It makes sense to me. I think the big question is, will they do OUI manslaughter or manslaughter? For extra years, I would give her manslaughter. Lally didn't win the motion for all of Gretchen's material during the first trial. Trevor McIntyre asked, how did Lally not use this? I don't think it was redacted. They just didn't win these records, and Gretchen didn't cough them up. She should. I mean, I think Gretchen's clearly going to be a witness. There's no question. If this goes to trial, Gretchen Voss is getting on that witness stand. I think someone said My King of Kings said the jury will love Hank Brennan. That's the most important thing. I agree. Lucy R. says, I think Karen Reed will fight to the finish. We might get to the finish before trial. AJ thought he was great yesterday. Yeah, I didn't think Alan had his best day yesterday. Karen has zero self-awareness. Agreed. Lally was bad, but Bev tied his hands and let all kinds of things in. I think Lally was just overwhelmed with the material and did a yeoman's job for any ADA. 8 out of 10. What happened there anyway? Why were they late? I think they tactically were late to that case so they could walk in and cause a show and all that. It just pissed the judge off clearly, and he ruled against them. Karen Reed, that is. Karen's very disrespectful Karen and her lawyers are very disrespectful to John's family, yeah. Someone said they think Karen has borderline personality disorder as well as major narcissistic traits. I don't know. I'm not qualified to analyze that kind of thing. And someone said she's a drunken psychopath. I don't. You're entitled to your opinion. Someone said Hank Brennan is a defense attorney. The amount of disdain he must have for what has taken place with these attorneys is palpable in piercing attorney-client privilege. Yeah, I agree. All right. So let's see. We're almost caught up. TB's text said, tell Jen, TB's text said that Karen basically told TB to ask, and they weren't texts, they were group chats from a Facebook message in May, I think May 3rd of 2023, around like 1:42 to 1:47 p.m., maybe 1:31 or so, that they were text saying that basically Aidan was outright admitting that Karen told him to run Jen McCabe's plates, which Aidan did through a police dispatcher now fired named Janelle Webb. And then also that Karen told Aidan to ask Jen McCabe questions at a children's lacrosse game. And that's interesting because it was Richie Microdots, like Karen's like one of her PR people, who went with Aidan to film at that children's lacrosse game. So there could be something there. Someone said, Karen thinks she's smarter than Hank, but she's about to fuck around and find out. Yeah, no, Karen is not smarter than Hank Brennan. No one in that room is smarter than Hank Brennan. There are people in that room who might be more media savvy than Hank Brennan, but even then, Hank Brennan has a pretty good command of that too. Someone said Hank Brennan's a shining light for sure. Yes, he's like a city on a hill. We shall build a city on a hill, and we shall call it Brennan. Karen hates Brennan because she can't outsmart him. Yeah, I agree with that. The end is near, said Melanie. Yep. The My King of Kings says, I just can't see her doing that. Her narcissism won't allow it. Yeah, I agree. Kitties1993 says, Grant, great to see you on this case again. I read through your ex post and your comments on Kate P. resonate with me. I defended her initially in chats, but learning about the manipulations, unethical. Yeah, I agree, Kitty. That's a good analysis. I think Kate Peter and Aidan Kearney are similar. Kate Peter just hides in plain sight better, and I went on a long soliloquy yesterday saying that I think that's even more dangerous, because at least Aidan will stand out there and be like, I'm an asshole and I am unrepentant about it. But Kate Peter, she will try to be like, I'm a defender of the vulnerable or whatever, and it's like, no, you're not. You fucking subversive, manipulative, in my opinion, dangerous human being. I've seen Kate Peter do so many things that just absolutely blow my mind and concern me. Like, Kate Peter didn't organize those courthouse protests for John's family during the first go round. She was like invited at the last minute. And then I watched this happen in real time. I still have the screenshots. While the group was there, and after they had bought signed material and whatever, Kate put up posts on 2 different days during those protests asking for donations, which she said were going to go to offset sign-making material costs and pay for people's lunch. Bullshit. I think Kate collected a lot of that money. There's no record of how much was collected in total or who was given it. And I think some people eventually, even though they paid for their own lunch, were like, oh, Kate paid for my lunch. But other people to this day will tell you that they were there that day. No one ever offered to pay for their lunch. They happily paid for it themselves. Meanwhile, Kate was collecting fucking donations, claiming that she was going to pay for the lunch and all of that. Bullshit. That was the most subversive PR move I've ever seen in my life. And that's just part of the larger picture here and Kate Peters' connection to Brian Tully and Jen McCabe, and the way they may have, in my opinion, intentionally released Lindsay Gattani's cell phone extraction on April 24th, 2024, just days before Karen Reed's first trial, with messages from only Kate Peter and Brian Tully removed as a way to deflect the Turtle Riders' attention from Jen McCabe. I was like, what the fuck? How could we get to this point as a fucking society? Like, just the level of just evil is unrepentant, and it forsakes the cause of justice for John O'Keefe, and it just forsakes the solemnity of this process that we, as I've mentioned, have this kind of stupid Watergate style, right, a very degraded form of state-level intelligence community tactics with Kate Peter and this PI firm she used to be attached to, maybe still is, run by some guy named Marty Kraft, who's and that whole group is in the orbit of the state police attached to the Norfolk DA, and then some of the witnesses in the Reed trial. You got that proxy battle occurring with those folks on one side, and then on the other side you got the federal government and the DOJ and their intelligence community tactics. And you can look at Steve Miller and Buffalo Jim from the early 2000s and the Crazy Horse 2 to see how artificial attention on a case like the investigation of John's death is perfect federal cover to pretextually do 2 things. One, engage in like petty political squabbles. Rachel Rollins, for example, taking out a old grudge against Michael Morrissey. Same thing with Dustin Chow, line prosecutor, maybe the head of the public integrity section at the old Boston DOJ under Rollins. The DOJ, 1, does that kind of thing, and then 2, has a reputation, especially under Rollins, for launching pretextual federal probes, like the fake probe launched into Kevin Hayden, who won the Suffolk DA race over Rollins' ally Ricardo Arroyo, and then Rollins got forced out of her position because the DOJ OIG found out that Rollins, in response to Arroyo losing the Suffolk County DA primary, launched a pretextual federal investigation into Kevin Hayden, then recused herself from it, leaked the recusal letter to the Globe and the Herald, and tried to use that to smear Kevin Hayden. Sound familiar, folks? Sound familiar? But then the third element of this DOJ proxy battle is, if you really look into Steve Miller, Buffalo Jim, the Crazy Horse 2, what you will see is that running these kind of pretextual federal probes also serves a third purpose. You can drive leads. The FBI knows what search engine optimization is, and it knows how to use a blogger like TurtleBoy to create artificial AstroTurf honeypot attention around one case, while in reality driving leads about other cases. And why do you think? In turn, it was in the fall of 2023, just a few months after the probe of John O'Keefe's death. The federal probe starts up and quickly ramps down because there was no indictments, no charges, and nothing is there, or otherwise, and it's now confirmed as closed. The federal probe of Sandra Birchmore's murder cover-up opens in August of 2023, and it's the very same MSP unit attached to the Norfolk DA who signed off on the police report confirming Sandra Birchmore's death was originally self-harm, despite the fact that the MSP had video evidence from that Friday night when Sandra was murdered showing that Matthew Farwell was at her apartment complex, not to mention all of the text messages going back years between Farwell and Birchmore showing grooming and serious abuse and threats to like choke her to death. It was horrible, okay? And that unit signed off on that as the result of self-harm. So clearly, in my opinion, the DOJ was kind of like giving Karen a wink and a nod, and TurtleBoy being like, hey, like, good, look what you found, you know, like, you led us on to this. And it was because the John O'Keefe case was used as an artificial honeypot, and Aidan's influence was artificial from the beginning. All the coverage of the case, all of the way that it permeated throughout the media ethos and the online sphere. Artificial honeypot designed to bring in information about the state police and that unit in particular, in my opinion. However, again, I think things get very, very complicated towards the fall of 2023, though, because for whatever reason, the state police catch wind, in particular, I think Brian Tully, that the federal probe is not really into John's death, that it's about Sandra Birchmore, and they start getting nervous. At the same time, Lindsay Gattani, a local independent reporter who's just brilliant, finds out that TurtleBoy is blabbing that Karen's telling him that Karen Reed has a connection directly to Josh Levy, the former U.S. attorney. And Levy's telling Karen things about the case, about the grand jury, and TurtleBoy's bragging about it. And then you have Brian Tully, I think, trying to, in the criminal investigation of TurtleBoy for witness intimidation and things like that. I think Brian Tully catches wind that Aidan is bragging about Karen's connection to the DOJ, and then Tully attempts to use that to find out information about what the scope of the federal probe is about. And I think Kate Peters' job in some way is to stay close and manage the narrative of all of this and the way the criminal cases play out, so that the information that is out there about some of the tactics that were used both by the feds and by the Norfolk DA and the people in that office's orbit as to this proxy war involving Aidan Kearney and Kate Peter, and their tactics they were deploying don't actually come out. And I think some of those tactics bubbled to the surface a little bit with, as I mentioned, the manipulation and leak of Lindsay's phone records. But I think we've seen Kate's kind of shadowy black hand style efforts popping up way more than just that. And maybe people are getting to the point where it's all getting put together. But I think we got way more layers of that glass onion to peel, in particular as to whether Kate and Aidan run people out there as like moles to each other's side. You know, you have people out there pretending to be pro Karen Reed, pro TurtleBoy, who are really moles for Kate, running information back to her because they're actually not supporters of Karen Reed or TurtleBoy. And then I think you have people out there pretending to be pro justice for John O'Keefe or pro Lindsay or whatever it is, when in reality they're feeding information back to to Aidan. Very, very obviously people who are pro Lindsay support Lindsay, but very, very clearly there are people who are pretending to be allies of each of these movements in order to get close to others, in particular close to TurtleBoy and close to Kate Peter, to feed information back to the other side. That all of those layers connecting together actually paint the mosaic of what went on here, which was, it's pretty simple. The DOJ was being petty with the Norfolk DA, but the Norfolk DA and the MSP unit had Birchmore's cover-up to hide. And the O'Keefe probe, although it went nowhere, did find out about things that shouldn't have been happening within that MSP unit. That, and nobody really wants to talk about it. That's what I think happened. That's my opinion of what happened. I think there's a little more underlying the social dynamics of like why Karen hates Jen McCabe before even Karen backed her car into John and etc. As to the series of events that followed with Karen trying to come back to the scene at 5:23, confirm John was dead, and then leave again, go pick up Jen and Carrie and try to stage like seeing John for the first time after 6 a.m. Setting aside the social dynamics of Canton and what might have been going on there, I don't think that's really what people are like embarrassed about. No, what I think is like really sensitive about all this is that people play loose and fast with the rules on the federal level and on the state level, and Aidan Kearney and Kate Peter are just embodiments. They're the public-facing apparatus that we see, but there are power brokers behind them who we don't see that dangle their little puppet strings, and that is why it's so hard to understand all of this. Why would anyone ever tolerate Kate Peters' behavior or tolerate Aidan Kearney's behavior? You know, some of these, I heard Kate one time say to my face, she was like, oh yeah, you know, I don't buy into all that religious bullshit. Say that to Miss O'Keefe's face. I dare you. You know what I mean? Like, and just obviously Kearney says just an absurd amount of ridiculous shit, and they both do ridiculous things. So why would anyone tolerate them? Well, there must be some trading of tolerance for efficacy as to what methods deployed by Ms. Peter and Mr. Kearney are able to yield for their various constituencies, if you want to call them constituencies. But needless to say, yeah, bring up Kate Peter and I'll go on a bit of a spiel. I don't want to take too much time away from these motions. So let me go back to the motion and then I'll try to get caught up on the comments again. But yes, that Kate Peter story, there is a lot to it. And ask yourself, folks, over and over again, why were only messages from Kate Peter and Brian Tully deleted from a 15-year extraction of Lindsay Gattani's cell phone while it was in the possession of the state police in sometime between January and April of 2024, and then why on April 24th, 2024 was a 15-year unredacted extraction of Lindsay's phone, including sensitive photos from when she gave birth and all this other stuff, handed over by Tully personally to Aidan's lawyers, with only messages from Tully and Kate Peter, not to each other, from Kate Peter to Lindsay, and from Tully to Lindsay, removed from the extraction. There's some serious shit that went down there, especially if the implications are that material was leaked on purpose by a member of the state police so that Lindsay would become fodder and a distraction for the Turtle Riders and they wouldn't focus on Jen McCabe. That's the level we could actually be talking about here. So, of course, there's all these motives for people to sort of manipulate and massage the narrative, and you have these overlapping concentric social circles where some people flow in different circles, and they all have these similar motives, which is narrative control. All right, but now this is pulling us back here. What I really want to find out about Karen, this weird documentary with, and who knows how it'll all play out, but with Gretchen Voss and Kate Peter trying to get involved and put her like weird people in the documentary who have nothing to do with any of this. And this was Gretchen withholding information that was very damning to Karen and would have far increased chances of conviction because of Gretchen's own motives, either not wanting to be called to the stand or saving the information for some later project. That's ruthless. Little unassuming Gretchen Voss. Don't judge books by their covers. Seriously. You can even just don't do it. Like that, being underestimated is a tactical opportunity for a mind like that. And that's clearly how Voss plays it off. I mean, I'm giving her a lot of credit by saying this, but don't think for 1 second that Gretchen Voss is not very cerebral and intelligent and calculated. She is very smart. I mean, she's probably one of the most established print journalists in Massachusetts. Obviously, her and I have very different styles. She's a more conventional print journalist, but yeah, one of the most established print journalists in Massachusetts. Let's see here. And I think she works for the Globe now, doesn't she, technically? Because I think the Globe bought Boston Magazine. Like this month. Does that mean... Oh, that's interesting, because I think that might mean it's per outlet. So if the Globe owns Boston Magazine, the Globe can only send one reporter anyway to the Reed trial. Let's see. All right, so that was that first part from the Gretchen interview. Second, in a Vanity Fair article entitled Karen Reed Tells Her Story, Part 1, a murder trial in Massachusetts. See, that's what I mean. Whoever said that was this redacted? I don't think it was redacted. I just don't think it was disclosed before. This is actually huge. This has very large implications, because what it potentially means is that this is the first time we're learning that Karen said that about what David was relaying to her about her potential criminal liability for incapacitating John by hitting John with her car in those days, like between January 29th and February 2nd of 2022. My God. Oh, wait a minute. That's why he put them on the witness list. I just realized. So in Hank Brennan's updated witness list, the two names that were added to like the civilian witness list that were the most eye-catching were Natalie, the intermediary between April and June of 2023 between Karen Reed and Aidan Kearney. Natalie is on the witness list, and then John O'Keefe's mom, Margaret, Peggy O'Keefe, is on the witness list. And you can tell Peggy's on the witness list because Peggy was at John O'Keefe's home with John's thrice at that point orphaned niece and nephew, along with Papa O'Keefe and Paul O'Keefe and Aaron O'Keefe that morning when Karen, after going back to the scene of John's death around 6 a.m. or so and like just melting down, starts threatening to take her life, and then Karen's parents call the police and have Karen sectioned. And it's actually because of Karen's dad, I think, calling the police and having Karen taken to the hospital, Karen's blood alcohol gets taken. Well, after 9 a.m. or 8 a.m., whenever it gets taken, that BAC was still at 0.08. Retrograde BAC conversion analysis shows Karen's BAC at 12:31 a.m. to be between 0.13 and 0.29, anywhere between 2 and 4 times the legal limit, basically. After that, Karen gets out of the hospital. She's taken to the same hospital where John dies, by the way, and all she was thinking about it was whether John had died. Like, you could tell she was only worried about her own liability. And Karen gets eventually discharged from the hospital. Her parents, instead of taking her home to Dighton in a blizzard, her parents and then her brother and her brother's wife, who's also on the witness list now, Nathan's wife, Bordeaux is her last name, Caitlin Bordeaux, Kaitlin, I think. They, instead of taking Karen home to Karen's parents' house in Dighton or Karen's house in Mansfield, they take Karen back to John's house at Meadows Ave in Canton, where Karen spends 15 minutes. Karen calls Aaron O'Keefe, okay, and John's sister-in-law, and says, I want to come over to comfort the children, the niece and nephew. Karen gets there, says very little to anyone, and then goes upstairs with her dad for 30 minutes or 15 minutes and just is alone, collects some of her stuff. Did she delete Ring videos? I don't know. To collect some of her stuff, and then they collect the murder weapon. They literally take the Lexus and they drive it back to Dighton. Now, just to be clear, Karen's taillight is on video broken at 5:08 a.m. when she leaves John's house, at 8:23 a.m. when the Canton PD pull up to do a wellness check, and there's video of Karen's taillight clearly broken in the driveway at 8:23. And then Karen's taillight is seen again broken on camera at 4:12 p.m. before, right as the state police are arriving to pick up the vehicle and transport it back to the Canton PD, where it arrives into the Sallyport for further crime scene forensic examination at 5:26 p.m. or so that evening. Okay, that series of events, in particular, Karen's dad taking Karen with the brother back to John's home in Canton, and Peggy O'Keefe having this moment where she saw Karen's broken taillight in the driveway early that morning and basically knew Karen killed John and said it to Karen. And then, of course, you got the phone call right before Karen arrives back at her parents' house in Dighton. I forgot this part. Karen calls Aaron O'Keefe and says that she'll have to remember the bad times. This is Karen to Aaron. And that Karen will probably never see Aaron again. And then they never spoke. Aaron was like, no, we'll talk. You know, what are you talking about? They never spoke again. Karen never reached out again. So, yeah, there's a lot to be said about, Oh, that's what I was going to say. So the witness list, it had Peggy O'Keefe added. That whole spiel there was just going off of why Peggy O'Keefe being added to the witness list is such a big deal. But you really have to contextualize it to explain it right. But then also David Yannetti, Alan Jackson, and Elizabeth Little were added to the witness list. Folks, this is why they were added to the witness list. Folks, this might actually work because there's no privilege if Voss was there. Voss is going to get asked about this statement, and then the attorneys can get called as witnesses to confirm Karen said that to Voss, but it's on recording. Wow, folks. Look at Brennan's telling us. He's giving us hints. That's why they're on the witness list. This statement is huge. Wow. You really have to know what you're looking at. But that has momentous implications. That Brennan finding that is huge. Second, in a Vanity Fair article entitled Karen Read Tells Her Story, Part 1, A Murder Trial in Massachusetts, with a caption, as Karen Read's second murder trial looms, she's ready to talk about what she says really happens, published on October 29, 2024. The defendant, who according to the publication was notably aware that anything she said could be used against her, volunteered a rumor that alleged representations made by the MSP that there is text message between her and counsel that implicates herself as a provable lie. Third, in the now airing 5-part documentary series on investigation discovery in HBO Max, entitled A Body in the Snow, The Trial of Karen Read, the defendant professes, and then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot? What if I ran John's foot over? Or what if I clipped John in the knee and John passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. Wow. The privilege holder is the defendant. And the defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client. See in the matter of John Doe grand jury investigation, 1990. In addition to rendering the communications non-privileged, the communications are relevant as admissions and statement of the defendant. These statements are admissible substantively, and Attorney Yannetti statements to the defendant are admissible pertaining to the defendant's state of mind. Also, the defendant's admissions and Attorney Yannetti statements are relevant to challenge the defense's later purported claims of third-party culpability. Right, because why would you don't have a third-party culprit if you knew from the first few days that you may have hit him and there was liability for that? The third-party culprit then becomes evidence of your guilt because you were trying to cover it up by making up nonsense conspiracies. Let's see. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested that as part of its defense, it is likely to pursue a Bowdoin-type defense. The potential evidence is relevant to rebut claims of law enforcement contrivance. So, exactly, this is really powerful. Brennan wants to use these in the case in chief against the defendant, and then Yannetti's statements come in, even though Karen relayed them, because it's state of mind. Karen was saying what she thought. She was directly saying that's what she was thinking about at the time. Wow. And then we're going to see this next part as well. Hank Brennan files a motion for records to the HBO Max company, because HBO Max and Investigation Discovery wouldn't turn over all their records. There might be more that documentary got that didn't air. And so Brennan sends a subpoena, well, it puts in a motion for records. And we're going to read that as well. But I realize it's past 2 o'clock, and what we should do is take a look at the docket and find out if anything has gone up in the past, 22 minutes. I wonder if there were a ticker of how many times I loaded this docket. It must be like, I don't know, 7,000, 10,000. Because you can't, they have all these protections. I don't know why they're so opposed to it. I guess because it takes a lot of bandwidth. But they will not let you scrape mass courts if your life depended on it. Like, there is just no way. It's designed in such a way where you can't script it to monitor updates. They want you to monitor by hand. And they really want you to earn it. There's no reason for it. I think it's just like a custom in practice. Even Pacer lets the media get case alert updates. Nope, nothing new up on the Reed docket. All right, so let's continue. This is actually the newest motion on the Reed docket, which is the motion for productions of records. But before we get on to that, let me get caught up in some of the comments. Oh, more and more you keep watching on YouTube. I'm thrilled for that. This is a small YouTube channel. Obviously, I do way more streaming over on X, and I write a lot more content over on X, but I'm grateful to have you with me. My name's Grant Smith Ellis. It's coming up on 2:30 on this Friday afternoon. It's March 21st, 2025. Relatively nice day in Boston, about 44 degrees Fahrenheit as the day begins to come to an end. I am enjoying it. Hope you're enjoying being with me. Thanks very much, by the way, if you're tuning in. We just went over the two pieces of information. Karen Reed's denial of her motion for stay up at federal court to try to stay her state court proceedings. That was never going to happen. Before jury impanelment begins on April 1st with one of our final motion hearings on March 25th. And then we just went over Hank Brennan's motion to obtain records from, or cell phone records already in possession of the Commonwealth, but subject to review by a taint team. Permission to review specific communications between David Yannetti and Karen Reed over the days of January 29, 2022 through February 2nd, 2022. For the purposes of using those statements to show that Karen Reed, basically from the very beginning of this case, knew that she backed her car into John O'Keefe, and because she was worried about the criminal liability, came up with a ridiculous third-party culprit defense. So let's read some comments before we go on to the third motion, which is a motion for Hank Brennan for Hank Brennan for records from the new investigation discovery documentary, the 5-part series that is already damning to Karen just based on what aired. But Brennan wants all of the records related to the production and presentation and drafting of that documentary, and we're going to read that motion up next. But I'm going to get caught up on some comments. Amber Am says, no way Karen will take a plea because she will have to admit guilt. She won't do it. Plus, I don't think Hank will offer it unless she admits guilt. Plus, she will be sued by everyone and won't plea. I don't think she has anything left. You can't. What are you going to get? Blood from a stone? I don't think her civil liability is actually they're going to sue, but TurtleBoy has way more civil liability. I think he has more money coming in. Justice for John O'Keefe and his family. I agree. Great coverage. Great to chat with you guys. Back to working. Good to see you. Dewdrops. Justice for JJ. She should have hired Hank to defend her. I don't know. I hope he wouldn't have done that. No way Hank would go with any cover-up BS. Yeah, I agree. That's why he's calling Natalie. I wonder if Hank Brennan's going to call Lindsay. I don't think Hank Brennan will cover up anything. I think he'll just be like, this is what it took to figure out what Aidan and Karen were up to. The people of Massachusetts deserve reparations after this trial, and with it we will build a statue of Hank Brennan. Listen, I'm all for building a statue of Hank Brennan. Lucy R. says, Kate is dishonest as fuck. Speak it, Grant. Lucy R. sounds good. You're winning me over here. I don't know who you are, but I like your peace symbol, and more power to you. Let's see. Josh Levy is sketchy as fuck. I agree. Kitty says shady shenanigans. New banger channel on this farce and circus. Thank you. Well, thanks, Charles P. Coletta. Thanks for being with me. I do a lot of coverage over on X, Grant Smith Ellis there as well. But and you can find some coverage on my YouTube channel from like the first trial where I would cover some of the longer motions. But I haven't been doing a lot of the second retrial. I just started up this YouTube channel again. So yeah, feel free to subscribe. Give the video a like. Apparently that helps it in the algorithm if you subscribe from the video. But anyway, more power to you. You can also watch on Twitter, but you can't leave comments on Twitter because I cannot keep track of all these comments on the Twitter platform. The comments go off the video too quickly. Love your approach and ability to get the facts out quickly. Thanks, Fraud. I try my best. Hey, welcome, Murder by Maestro. Very good to see you. Goldie Lawrence says KR is going down. Murder by Maestro says something is wrong with me. I almost felt sorry for Aidan. He sounds so defeated. I mean, like, yeah, what do you do when the walls are closing in and your whole style is just fake it till you make it? I mean, it's a soul-crushing blow. That happened to Aidan when the federal investigation was confirmed as closed. It was just a matter of time before he actually realized the weight of his predicament. Someone said Miss O'Keefe with a heart. Yes. I didn't see Miss O'Keefe yesterday, but I think it was Paul. I don't know who was walking next to him at the top of the stairs when I was walking out of the courthouse waiting for Karen to leave. We were inside, like I couldn't get a seat because I was late, but I was just sitting inside the courthouse on a bench, and I saw Paul. I gave him the sign of the cross. I didn't say anything, just kind of turned away. I wonder if he looks at me and is like, that kid is like Batman. He pops up, gives me the sign of the cross from time to time, and just walks away. Let's see. Someone said they blew a .27 in college. I don't even know. That's pretty high. I think fatal alcohol poisoning happens at like 0.40 or 0.5, so don't do that. It's the lowest of the low to mock a mother who's just lost her son. Please give us justice for John. I agree. The timing of adding Natalie to the list couldn't be better. I also agree. My King of Kings said she deleted the Ring camera too. And then during that time, her and her dad and brother were her lookouts. Murder by Maestro said she was one of the first to talk. Oh, I wonder if they were her lookouts. Yeah, that's a good idea. She deleted the Ring camera, and her brother and her dad were lookouts. They had a plan. Someone said the new trial should be much more compelling than number one, which is why they are fighting so desperately. The witness list alone has them shaking. Yep. Goldie Lawrence said, I've been following this for a long time, and this is the most process towards justice for JJ I've seen. Let's just pray no turtle tards get on the jury. Someone said, has anyone ever tried to cover themselves in Ring cameras? I don't know what that means. Someone said John's phone temperature is very interesting too. Yep, that one's definitely going to be telling because the phone will have been, we probably will show it going from like an operational normal temperature in the car to right after just a steady decrease, and then obviously it was in the cold and will have just zeroed out. That's a very good argument from Hank Brennan. Someone said Hank's playing chess, AJ begging for a delay knowing she's cooked. I agree. I do worry about the jury pool being tainted. Why the weird game of musical chairs? Yeah, that was a little awkward. Someone said AJ's like a 5-year-old with his do it remarks. Yeah, that was a little bit overly theatric. Someone said Karen's words are going to get her convicted. She's cooked. Yep. Did a judge just spawn and start taking arguments? No. It was scheduled on. Strangely, it was on Karen's docket, but it was a Rule 17 motion on Karen's docket. A man representing someone for murder behaving like that is embarrassing. I'd sack him instantly if he was my lawyer. Karen had the chance to sack him the other day. She said no. Someone said that was all for the camera. Hollywood Jackson. Yep. Someone said Alan Jackson's such a bad actor. That's why he became a lawyer. He couldn't make it in Hollywood. I think he kind of did make it in Hollywood. It's just he made it in Hollywood as a lawyer. Like that's its own version of making it. And then the other thing is, Alan Jackson has Hollywood connections too. Like this PR apparatus didn't just appear out of nowhere, and it wasn't just TurtleBoy. A lot of these people involved, like some of the YouTubers, I think, or the PR figures, like it's from Alan's world. Like he definitely runs operations. But the thing is, he normally has better cover because he works for very famous people like Harvey Weinstein or whatever. And you wouldn't see a media apparatus like this at play in the Harvey Weinstein case. It would be much more, or Kevin Spacey is what, Kevin Spacey too. You would see much more like conventional media manipulation because it's already a high profile case. What did they just have to sell the right media people? With the Karen Reed case, she's not famous, or she wasn't famous going into it. And so they had to create a movement that made her famous, that gave them the ability to run those tactics. And that's why it's also artificial. Not saying people don't authentically believe in Karen's guilt or innocence or whatever, but the people who were building up the Free Karen Reed movement weren't really doing it just because they cared about Karen's support. They were doing it because it was a hook for those people to run their PR operations, which require a certain level of fame for the subject of the operation, like Karen here. And that's why I think there was all that artificial attention on Karen by her team. I think it was a tactical effort to elevate her into the level of fame that would allow them to run their PR operations. They didn't want to design her a new PR operation. They didn't want to rewrite the book. They just needed to elevate her to a level of fame that would allow them to run their traditional playbook. Hank Brennan has been making it personal, make people feel a certain way. Hank Brennan has been doing well. I agree with that. None your business. Amber Am says, what happened to Chloe? The dog did it. You know, that whole theory came from Karen's mom, who Karen called her mom, didn't even show her a picture of John's injuries, his autopsy photos, just described it. And Karen's mom, without being told that there was no dog DNA or doing any investigation at all, just was like, it was a dog. And that's why the Chloe dog theory came out of nowhere and then went by the wayside, because there's no dog DNA. And none of the jurors in the first trial bought the dog thing. They all thought it was crazy. I could see it in their eyes when David Yannetti was like, it was the dog. They were like, what is wrong with this crazy man? No, Hank Brennan is not handicapped. Too many cooks in the kitchen. 1 against 4 is an advantage for, it's actually not 1. It's 3 against 4 because Brennan has Adam Lally in second chair and Laura McLaughlin. And Laura McLaughlin does argue some things, but she's really an appellate attorney. So she's foreshadowing, taking notes, thinking about appellate issues, foreclosing appellate issues with the structure, helping advise Brennan on his arguments. He's got a good team. And then Brennan's got an appellate team too, which is Caleb Schlesinger. He's got, Brennan's got like 4 people on this case doing different things. Let's see. Brennan is a professional. AJ and Yannetti should follow his example. Yeah, I agree. How did Alessi get involved? Alessi volunteered for free, I think because he wants to get some experience and attention. Someone said, I hope Alessi does the opening. No, it's going to be Jackson. I wouldn't put Alessi up there for the opening. He's a technical lawyer. You don't want a technical opening. You want bombast here, but even that's not going to save you. The problem is that people do want to believe that 1, KR could have planned this, and 2, that her reactions and VMs were pretense intended to mislead, and that 3, she doesn't care about hurting others. I think it's a mix. Right. I think, but it's a mix. Like KR did plan, like the whole thing after John. She hit John. I think the whole hours after 12:37 was all her scheming. Her reactions in VM and voicemails, some of them were pretense. But I also think some were her genuine reaction, like 12:37 when she screamed, "John, I effing hate you," or "You're a pervert." Definitely, I think those were intentional. Trevor said it's windy as heck here in Boston. Someone said the proof is getting in trial this time. Without reasonable doubt, her own words will convict her. Yep. Nanya said, I just watched the trial shows and root for my team. I do not wish to make myself a part of it like everyone else. Yeah, I mean, it's one of those, if you can understand it, so I think it's a few things. If you live here in Massachusetts, especially if you have any connection to like Dedham, like my family grew up there, and my mom's sister grew up there, so I spent a lot of time there as a kid. If you have any connection to Dedham or any connection to like Middlesex County or Norfolk County, like anywhere in this area, you're going to somehow be impacted by this. 6 degrees of separation or otherwise, like you are somehow going to be somehow touched by this godforsaken chaos. But if you can keep track of all the players and all the names and all the information from a distance, I think that's the healthiest way to do it. Although I think I'm able to keep track of all of this because it's so human to me, all of the people involved and the emotions and the names and the dates and the times, it's all a very real experience that I can see very vividly in my mind. A lot of these players I've ran into or asked questions to or know or whatever it may be. If you can do it without that, I think that's a virtue. There is definitely a price you pay. Even the people who get like this rush off of trying to like get themselves on like different documentaries or whatever it may be, like they're doing it for the complete wrong reason, and they're still paying the price for being this close to the situation. It's an incredible emotional toll. I mean, yes, I'm able to juggle other things, but there is a certain sort of all-consuming aspect of trying to understand all of this. I wouldn't say it becomes your life, but if it doesn't become your life, it is probably more difficult to understand. But no, that's not where I was going, because I do think you can understand it from a distance. But it's at the emotional toll of being so close to this situation. It might be worth it in some sense if you're authentically trying to tell the story. Like that's, I think, probably the one reason or way that this actually, the emotional toll of being so close to this horrifying situation is worth it. Any other reason, I think you're just tormenting yourself gratuitously. If your goal getting close to this is some ulterior ancillary motive or whatever, it's gonna torment your life and ruin you and consume you, and the social circles alone will just eat you alive, especially if you look for meaning by way of like friendship or, you know what I mean, like if you try to find meaning in your life by way of traditional social circles, this case is even more dangerous. Don't get involved in any of that crazy shit, because all of that stuff is just layer upon layer upon layer of conflict of interest. And it's worse than high school in a lot of ways, because there's some very real power dynamics involved in this case. And you may think you're just talking to some nice person who you might want to go to lunch with or whatever. But in reality, they're just the face of a very deep, dark, dangerous apparatus. It's kind of like the scene at the end of American Psycho. If you've ever seen the movie American Psycho, I've compared Aidan Kearney before, by analogy, to Patrick Bateman, and Karen Reed to the realtor at the end of American Psycho. And Patrick Bateman shows up to Paul Allen's apartment and expects it to be a murder scene, basically, and finds it completely clean. And this realtor, this old woman, looks like a grandma, white hair. You suspect something's off with her, though. She just has there's nothing warm about her. The juxtaposition of like this old grandma in a suit with her facial expression and her words. She says to Bateman, "Oh, you must be my 2 o'clock." And Bateman, a little bit taken aback, says, yeah, the 2 o'clock. And the woman says, "Oh, so you saw the ad in the Times for ostensibly for an apartment listing?" And Bateman says, yes, the ad in the Times. The woman says, "There was no," doesn't miss a beat, just says, "There was no ad in the Times." And then there's a pause, and Bateman doesn't say anything, and then the woman says, "I think you should leave." And that's what I worry people run into in this case. They think they're dealing with just these like nice, like friendly, justice-fighting, amiable characters on both sides, when in reality what they're dealing with is like one head of a very nefarious 7-headed dragon, and the head that is allowed to poke out in public is the one that can somewhat convey this ostensible veneer of benevolence and compassion, because the rest of them you'd just be like, oh my God, you're that evil realtor. But there's also something to be said about that analogy functioning on the level of Aidan Kearney and Karen Reed that's really interesting, because I do think Aidan thought he was like really smart, but he really, in my opinion, by analogy, was just like Patrick Bateman, like just kind of figuring all this like stuff out, like, oh, isn't this a rush? Like, look what I can get away with. You know what I mean? Like, he didn't literally drop a chainsaw, but I'll drop this proverbial chainsaw down the stairs and we'll see how that works out. And then you have Karen Reed, who's way more methodical, really actually plays the game. And, Kearney, I think, at a certain point did have that moment where he kind of looked over at Reed. Actually, you know what? I'm going to bring this up for you all because we're taking a little break before I go into this next motion. I actually made someone said, I love that you are smoking. Yeah, well, that's my medication. I actually have the same stomach condition as Karen. Two of my siblings actually don't have their colons. One had a 3-stage colectomy when he was 4. One had a 3-stage colectomy when she was 14. So we have a very serious risk of stomach disease progressing into cancer and things like that. So I have to be very careful about my stomach. And so I eat a lot of bland food, chicken, rice, pizza, whatever. And then I use flour-based medication because apparently, and there are some studies that show this, but the actual flour that I consume has this kind of like anti-inflammatory property that in particular helps with the issues that come along with colitis and Crohn's and things like that. So that was just someone saying I was smoking and me responding. But yes, I will pause now in our moment of levity to do a few things. One, I'm going to bring up that picture of Karen and Aidan that I want to show you all, the realtor and American Psycho picture. The realtor picture. And then we'll start on this next motion. And of course, my name is Grant Smith Ellis. Please feel free to continue asking your very interesting questions. I enjoy them. I hope you enjoy asking them. As always, you don't need to send any donations or super chats to ask your questions. Just go ahead and send them away. But if you do want to send a donation, this is like a public information service, a la PBS or something like that. And it's user supported. And if you like this content and the way that I do my analysis and the way that I present these documents and the way the software works, I actually do this at a loss, so your donations are appreciated. Someone actually sent a $5 donation earlier, so I want to say very much thank you for that. I think every time I do one of these streams, I'm always like, oh, I can't believe I spent another like $3 on Pacer documents, and then someone comes through and pays like exactly what I paid for the Pacer documents. So thank you very much. I really appreciate it. Whatever amount you send, even if I don't see them in real time, because my phone doesn't always update the donations, I go through and I read each one afterwards, and I really do appreciate them, and they mean a lot to me. So know that it is noticed and appreciated, even if I may miss them all because they don't alert me to the fact that they get sent through. I guess that would be one benefit of super chats. I would see it in real time, but I just don't like this idea of this hierarchical access to the ability to ask a question. Like, your question is, in my eyes, or your comment, adjudicated on its merit. So you giving money doesn't make your comment any more or less meritful. It's the same comment, same question. So I don't like the idea of people feeling like because they can spend money, their opinion is somehow prioritized over others. No, it's based on what you actually are saying. But I found the picture that I wanted to show you all, so let me just bring this up. There it is. How good am I? It's not perfect. I didn't do like amazing, but the Karen editing is much better than the Aidan because it's so close with Aidan's head. But I mean, come on, folks. That's the analogy I was making earlier. Just Karen in the background there, kind of looking like, oh, you thought you were playing this game? You aren't. And it's interesting. It's really the brain. Like, the external appearance is what most people focus on and kind of like asphyxiate to, or the of somebody's syntactical verbal abilities or whatever. But it's really the brain. Like, those two humans are not a reflection of their outer exoskeleton. They're a reflection of their brains. And I see, as smart as Aidan is at playing the political game, I think Karen is a little step above, 1 or 2 steps above him. Now, I think the people actually playing these proxy battles or whatever are 2 or 3 or 4 steps above both Karen and Aidan, but I think this picture is a good microcosm of what I was trying to convey. All right, are we going to go back to this motion? I think we can read a little bit more of the motion. Well, we haven't actually started. This is the motion for records related to Karen's recent interview with Investigation Discovery, so we will take a look at this. All right, here we go. Oh, that's why I'm not getting the notifications, because I literally put my phone on Do Not Disturb. Okay. Hold on, I'm going to fix this so that if you send a donation and it's a very nice, compassionate comment, I will read it. I'm sorry I didn't see the other ones before. It was just too... it was silenced, so that's why I had to actually manually load it. All right, let's keep going. Commonwealth motions for records, Unsolved Productions, Inc. Now comes the Commonwealth and respectfully requests this honorable court, pursuant to Mass Rule of Criminal Procedure, paragraph 17, or Mass Rule of Criminal Procedure, yeah, I think that's part 17, paragraph 17. And Commonwealth v. Lampron, issue a court order 2. So this is a Lampron motion. Notice before we weren't dealing with a Lampron motion because the materials are already searched and seized. Now we're dealing with a motion under Lampron to a third-party record holder, which is Rule 17 as opposed to Rule 14 or something like that. Ordering the keepers of the records of unsolved productions to produce to the Criminal Clerk's Office of Norfolk Superior Court all unedited video and audio recordings in its possession of Unsolved Productions, Inc. and producer Terry Mowers from the docuseries A Body in the Snow, The Trial of Karen Read. Docuseries. That's a very common thing nowadays, a docuseries. I feel like back in the day, we'd only get docuseries about, like, Watergate or very high-profile incidents like that. But now docuseries are made on, like, a regular basis. Which, I mean, I think it's a good art form for the modern world, a docuseries, because people like to consume content on their own time, and no one's going to watch, like, a 6-hour epic, so they're just going to pause it anyway, so you may as well release, like, a 6-part series or 5-part series and let people watch it that way. It's a good way to do it. I think I prefer writing. I think the docu-series are good, but they don't have what this case needs. This case is so quick and so layered and so intricate that even telling it over 5 episodes with 20 different people and constantly resharing the evidence and et cetera, you can't really make the point. The only way you can really make the point is by giving the reader in front of them the material to look at and engage with over hours and 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 hours. And you can't, I think all of this video content is great. Obviously, I'm a big proponent of it. I help make it. I make these streams to help you all consume the content. But I think where we're all going to really benefit is, and there will be a few of them. I think there will be like 4 to 5 books about this case. But that's where we're going to really find the beneficial content. Not in the rushed books, and it's not going to be based on necessarily who's interviewed. You know, like I'll give you a little spoiler. One of the, and people can take this. I don't care although I care when you take my words. With this idea I'm suggesting of interviewing people in social media groups, etc., is very common. So you can do whatever the fuck you want if you're writing a book. But one of the ways that I'm going to write this book is I'm not going to interview the people who were seeking out attention. I'm going to interview the people who were just authentically participating. And I'm just going to be like, what was it like, what was it like to not want any attention, but be interested in this case? Like, those are the people I'm going to interview. I'm going to go to all these different sort of perspectives, but that's the one that I'm the most interested in. And allowing readers to actually take it in with the evidence cited in front of them and the motions and the pictures, that I think is going to be the strongest way to do it. Now, yeah, I do think that that kind of book does require this kind of supplemental interview or explication. Like, I think to make it a living, breathing work, I will have to actually go out and talk about it, but I don't really want to do that. Like, I'll go on C-SPAN or something. If somebody asked me to go on C-SPAN about a book I wrote, I would do that. I would give like a 2-hour interview on C-SPAN. That is what would interest me, but only for the purposes of kind of helping people understand and humanize the work. But yeah, so I don't know. I just think that if people are going to consume this, docuseries are a great way to do it, but I don't think they are going to have the kind of cultural staying power beyond kind of like clips and sound bites or references in court motions. I don't think they're going to have the cultural staying power that a tome is going to have or a canonical work. And I don't think, and it's kind of why I kind of just disregard people who are rushing to get this done. Yeah, we're still living this, all of us who are going through this or watching this or somehow impacted by this chaotic overlapping series of events. We're still living it. Like, how can you possibly, I get the investigation discovery documentary was more a chronicle of the first trial, and they also had like a falling out with Karen apparently, so I get why that came out. But why? Because you're telling the story more of the first trial, which ended in a mistrial. So if you just end it there, that's fine. But I don't get why anyone would even attempt to try to tell this story in the middle of it. It's like writing a headline about a court document without actually reading the court document. Like, what are you summarizing? Like the title of the motion? Or the ruling, like, what that says, but like, how can you write any part of a story or any part of a text unless you know how it ends? And so that part, it kind of blows my mind. Like, a lot of people are talking about how they're trying to tell this story already, and I'm like, what are you telling? Do you even know enough of the full context to understand that you aren't ready to tell anything yet? So, but let me caveat that by saying the one exception to that I've seen so far that was really good was the investigation discovery documentary that I'm only halfway through. But it was because it framed this in the perspective of we know we can't tell the whole story because the story's not over. Now, we're going to continue reading this, but I would like to note that whole digression started because of the word docuseries. So it wasn't your fault, any of you commenting or watching, but just one word can set me off on quite a digression. So say any word in the human lexicon at your peril, because it might send me on a 10-minute rant. At least it was cogent and related and all tied into a larger point related into the motion, but which was mostly me riffing on how much I despise culture vultures and clout hoarders. All right, so we're still reading Hank Brennan's motion for records, and Brennan's going on to recap a little history. Proper legal motion always states the procedural or factual history of the case in a brief way, but in a way that catches even an uninformed reader up very quickly. And remember, you're writing for a judge. In support of its motion, the Commonwealth states the following. On June 9, 2022, the defendant was indicted by a Norfolk grand jury for second-degree murder in violation of GLC 265-1, manslaughter while operating under the influence in violation of GLC 265-13, 1/2, leaving the scene, a personal injury, death in violation of GLC Chapter 90, 24-2A-2. A jury trial on all three indictments began on April 16, 2024. Following a deadlocked jury and a finding of manifest necessity, the court declared a mistrial. The defendant's retrial is scheduled to begin on April 1st, 2025. However, the Commonwealth has assented to the defendant's request to temporarily delay the trial due in part to the defendant's appeal to the First Circuit Court of Appeals. We find out that the court denies that motion. This was written before the court denied it. On March 17, 2025, and March 18, 2025, and March 19, 2025, Investigation Discovery and HBO Max aired a 5-part docuseries entitled The Body in the Snow, The Trial of Karen Reed. The aired docuseries is approximately 4.5 hours of a behind-the-scenes look. When Hank Brennan does that, it means he doesn't think the phrase is worthy of being an illegal motion. Behind the scenes. Look at the defense team as it prepares for the April 2024 jury trial and features extensive interviews with the defendant Karen Reed, attorney Alan Jackson, attorney David Yannetti, and attorney Elizabeth Little. Terry Maurer, president of Unsolved Productions and the producer of the 5-part docuseries, has described in media interviews that the access to the defendant and her defense team was unprecedented. Unprecedented? Unprecedented? Or unprecedented? Did she say unprecedented? As part, maybe it's that way in the context. As part of this docuseries, the defendant and her counsel permitted cameras to record their trial preparation session in the war room. The car rides to and from court where the defendant and her counsels discuss opening testimonies and trial strategies, often commenting on the evidence, prosecutor, or the court, and one-on-one interviews with the defendant and defense counsels. Every statement made by the defendant pertaining to the facts and circumstances surrounding the death of John O'Keefe is relevant and evidentiary, especially given the nature of past statements made by the defendant. I'm checking the docket for you all, by the way. You got to check the docket every half hour. In the 5-part docuseries, the defendant again makes inconsistent statements with previous statements she had made to law enforcement, witnesses, and, most revealing, to other media reporters during other voluntary interviews. All right, Hank Brennan, let's see what you got to offer here. For example, the defendant now claims that she unequivocally saw John O'Keefe enter 34 Fairview Road and admits to consuming large amounts of vodka and being significantly impaired. Her position, even within the 5-part docuseries, wavers from a claim that she remembers every detail from January 29, 2022, to admissions that maybe her memory wasn't as clear when she hadn't been drinking. That's true. She did say she did waver on that. Oh, Karen. Oh, your own worst enemy indeed. The defendant confirms animosity in her relationship with John O'Keefe, confirms the altercation with Marietta Sullivan in Aruba, confirms her flirtatious text with Brian Higgins. It was more than flirtatious text. Confirms that she was angry with John O'Keefe and convinced that John may have been cheating on her with other women who resided in the neighborhood around 34 Fairview Road. The defendant further discusses going to John O'Keefe's residence during the late morning of January 29, 2022, and mocks Miss O'Keefe's opinion that John looked like he had been hit by a car. Yeah, Karen, you know what? We're going to watch that, Karen, because I have some of these clips, and that one just made me sick. All right, hold on a second. Where is this thing? All right, there we go. I keep these clips just at the ready because for whatever reason, how many are you watching today? Oh, good, decent amount of towel friends. I keep these clips at the ready because sometimes they just come up in motions, and then being able to refer to them is actually incredibly helpful. So let's take a look at the clip Hank Brennan is referencing here. This is just like 2 days of my Twitter feed, by the way. Where is this one? I know it's a specific clip because Karen's face is very expressive in said clip. It's not that one. It's not that one. It is not the butt slap. Where is it now? There it is.
And his mother leans over the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car. And his mother leans over the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car.
So what do you think, friends? Did Hank Brennan accurately describe Karen as mocking Miss O'Keefe there? I would say yes. Contrary to representations made to the court on March 18, 2025, okay, 3 days ago, the defendant admits on the March 17th, because did Karen say in court that she had never had contact or something with Aidan? I think her lawyer did say something along those lines. The defendant admits on the March 17, 2025, because Jackson was like, we don't instruct people to do that. We didn't relay things, or Karen Reed didn't instruct people to do things, and they weren't acting on behalf of Miss Reed. Contrary to representations made to the court on March 18, 2025, the defendant admits on the March 17, 2025 aired episodes that she uses an intermediary to share discovery with Aidan Kearney. That was Natalie, who's now on the state's witness list. Then, with permission of her defense counsel, shared public information, quote unquote. Hold on a second. Presumably all discovery provided to the defense that would ordinarily not be deemed public due to the investigatory nature of the prosecution with Mr. Kearney. Mr. Kearney then used this material to advance the defendant's narrative and direct harassment of witnesses. Wow. Further, contrary to representations made to this court, on the March 18, 2025 episodes, the defendant expressed reckless indifference that the witnesses, many who came to the defendant's aid, have been intimidated and harassed, and the defendant stated, "Jen McCabe, it's me or her. Either I'm going down, Jen, or you are." What the fuck? Jen McCabe was never going down for anything because she didn't do anything wrong other than answer Karen's call and go with Karen after Karen had already gone, in my opinion, at 5:23 a.m. back to Fairview Road to confirm John was dead. All Jen McCabe did was answer the call from Karen. And it makes you wonder if Carrie Roberts wasn't even supposed to be involved. Like, did Carrie just offer to come over? Was it just Jen? And then the other thing is, why did Karen say she had kissed Carrie Roberts before in a manner similar to how she kissed Brian Higgins in the basement of John's home? And that's weird. Although it could be another Carrie, but it was Carrie spelled in the way that Carrie Roberts is spelled. So that's weird. And just the whole thing is weird. Like, why does Karen hate Jen McCabe so much? Like, there's no reason for it. Like, why was Karen thinking, because if everything was planned out, then that means Karen choosing to call Jen to ask for help, because remember, she didn't have Jen's number. She had the niece call Jen and Carrie. Why did Karen think those two? That part's interesting to me. Was she framing them? Was she setting them up? Why Carrie, though? She didn't even cross Carrie. Interesting. I wonder if maybe if it was, the idea was always to try to blame Jen, but to bring Carrie as like an example of, oh, see, it wasn't Karen wasn't framing them. You know, Carrie didn't do anything, but I don't know. There's more I got to think about there. Why Jen? Why did Carrie have the niece? Why did Karen have the niece called Jen? And why did Karen go to Jen's house? Like, why? What? If it was all planned, why did Karen want to blame Jen for this? This 5-part docuseries is also ripe of new information. I should say falsely blame Jen for this. Why did you want to frame Jen for this? The 5-part docuseries is also ripe of new information previously unknown to the Commonwealth. For example, the defendant's statements that John O'Keefe exited her vehicle holding her vodka soda drink, that she clearly saw John's body from Carrie Roberts' vehicle, and that she pulled a small piece of glass from John's nose. Oh, so I got to catch that part where she admits to seeing the body from John's body from Carrie Roberts' vehicle, because there's no way that was possible from before the tree line. The defendant further reveals that her initial beliefs in the immediate aftermath of John O'Keefe's death, The defendant further reveals her initial beliefs in the immediate aftermath of John O'Keefe's death, stating to Attorney Yannetti and waiving any associated privileges, "What if I ran over his foot? Or what if I clipped him in the knee and he passed out, or went to care for himself and he threw up and passed out?" Yeah, I mean, there was no way she should have said that. And let me play that part. I think I have a few clips I can play for you here, actually. Hold on one second. A lot of cross-referencing of material. This is, I think, the clips of her. Yeah, here we go. I ask her questions in between.
Karen, that statement about glass in John's nose seems to undermine your entire case.
I ran over to him, and John is perfectly still. His mouth is open a little bit. He's got cuts and blood on his face, and he's just wearing the thin clothes he had on the night before. And he had a piece of glass, like, perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Also, you said you're a control freak. Don't you think that goes to motive for why you tried to yell at John when your relationship was breaking down? It was kind of a telling interview, Karen. I liked it, though.
I am not not going out of my way to catch this. I have not watched my own Dateline, and I've watched about half of 2020. And part of it is a personal challenge that I have so little control over my life, and I'm a controlling person in a lot of ways. And I have so little control that it's almost like a game I play with myself, that if I'm skeptical about this or skeptical of how I'm portrayed on Dateline, I will not let it infiltrate me. And I'll tell everyone around me, I don't want to hear about Dateline, or I don't want to hear about the document. If it's negative, I don't want to hear it. If there's negative things that are important for me to know or I should be aware of, I'll find out about it. But I do take some pride. I'm picking up Liza, and as soon as she gets in the car, I'll have to leave. Or
So, I mean, you can see it there. And by the way, I was reading some donations that were coming in, and that's why I was not smiling at Karen's statements. I was letting you watch while I was reading these. You can see from how Karen talks there, she knew she should. First of all, that thing about the glass in John's nose, that ruins her entire case. I'm 100% right with my question about that, and Hank Brennan's right to point it out. And Karen should never have said it. And then the thing about being, Karen almost said to the Glare, she's a control freak. I was like, oh my, I was like, oh my God, don't say that, Karen. You know, because it just shows a lack of an ability to speak in a refined way. Because even if you are a person who loves control, you don't say that. Oh, just you can see Bettero's just minding her on the stream. Bettero, who got his Pro Hawk VJ denied, so he's the only one who's not gagged. Oh, but the other thing is, I'm sorry, we were just referencing that clip because Hank Brennan had brought it up in the motion. I didn't want to overlook this. I got two very nice donations, two different $10 donations, and I just want to say God bless you and thank you to both of you. Obviously, you know, I will do this no matter what, but things are, you know, it's not that they're ever good or like really, really bad, but this end of the month is always never good, and I don't know, it's nice to not constantly wake up and, like, I think I like having, the reason I stay authentic is I don't really like money, so I don't, like, try to do that. I don't base my existence off that, but then, like, I get really nervous all the time because I'm like, oh no, like, how am I going to pay for gas to go to school or parking or medicine or doctor's appointments or the dentist or any other number of things. So thank you. It really touches my heart, and I don't really get it. Like, I think if it were up to me, I would just walk around the countryside in a robe, kind of like preaching philosophy to people and telling people to love each other unconditionally. But we don't really have, I think, a mechanism to allow for that in society. And I also think, that would just create a very weird dynamic because people would actually kind of like stand around and listen and I'd be like, why? This is just a weird situation. And I'd rather you'd all listen online so I don't have to look at you all standing around listening to me explain complex, convoluted, historical, synthetical syntheses. Because as much as I have fun doing it, I think if I actually, like, sometimes I'll say comments in class like that, and my professors will look at me just kind of like, oh my God, where is this coming from? And I, like, if I were looking out at all of you with those, you were just all wide-eyed, like, where is this coming from? I think I'd be a little overwhelmed. I think the only way I can do this is because I somewhat can keep some levity about me, even in the face of these difficult topics and otherwise. Okay, so what we're doing here, this is not gratuitous, by the way. What we were just doing is when Hank Brennan brings up a reference to something Karen Reed had said in one of her interviews, what I then was doing is bringing up the clips that I could find. So you didn't hear the part where she was talking about Yannetti, but you did hear definitely the part about the glass and Karen's, although Brennan didn't reference it, Karen saying she's a control freak. Although I think that actually really plays into Brennan's argument, because a breakdown in a domestic relationship in the lead up to a homicide can definitely come into play, and Karen saying she's controlling goes to that. Okay, so the defendant has repeatedly used the media to promote her position, explicitly stating in a Vanity Fair article, "If I can get the entire truth as articulated by the defendant of this case out in the public forum, that to me is priceless." So like earned media. I knew a lot of that was earned media. During this 5-part docuseries, the defendant declares that doing this film is my testimony. That's the stupidest thing I've ever heard. So that means all of it's going to be used against you. I want to see what happened exactly as it happened. That means she knew that. She knew this was all coming in. And her lawyers decided it was better to just let her do that than let her get on the stand and get crossed. It shows they don't her lawyers don't trust her at all. They do not trust her. She wanted to get on the stand and they wouldn't let her do it. Good call. Whoever kept her off the stand, good call. That's the only reason you got a mistrial. You put that woman on the stand, she would have been convicted. So whoever made that call, genius. That was probably the most brilliant, one of the few brilliant moves. I wonder if it was Eliza Little. Can you imagine just Eliza Little being just a lone holdout, like Jackson and Yannetti just being like, Karen wants to do it, let's do it. And Eliza Little being like, I am going to be the extraordinary dissent. And then just winning them over, and eventually Karen doesn't testify. Now that's a scene for the documentary. Eliza Little sees this, she'd be like, how the fuck did he know that happened? I can intuit things, Miss Little. I can intuit things. They could be omnipresent, too. You know, like I could just be processing all of this information because there's some energetic web that I can just tap into. I don't know how this stuff works. That's way beyond my ability to understand. Non-temporal cognition? I'll leave that to the experts. Could you imagine if this trial got to the point where we were having experts on media satire? Well, you see, this case has a dynamic variety of figures, and it doesn't necessarily ascribe to traditional conventional journalistic norms. For example, there's this guy who calls himself a towel, but he seems to provide very refined academic and intellectual perspectives on the case. Now, jurors, this reflects the very complex dichotomy of modern existence. We may look to the book Bowling Alone as an example of why people in an isolated social media ecosphere or ecosystem would, for whatever reason, adopt the persona of a towel. I could be an expert witness on towels. Sir, we have subpoenaed you, and we would like to provide you compensation to testify as an expert witness about the functional efficacy of towels, anthropomorphic towels, in the media environment. All right, there's your occasional moment of levity. We are right about at the 2-hour mark, so nothing wrong with some levity, and we are almost through this motion for records from HBO and Investigation Discovery. But let's continue along here. The defendant, oh, right, we already went by that. The trial by media this trial by media strategy. I love it. I love it, Hank Brennan. Trial by media. I love it. I love it. The man is inventing words. He's a modern Shakespeare. No, I don't think Hank Brennan has the rhetorical syntactical flourish that would designate him a modern Shakespeare, nor do I think if Hank Brennan wrote his motions in iambic pentameter, anyone would be very pleased. It'd be even funnier if it had, like, rhyming quadruplets just thrown in there for fun. He could probably do it, too. I was starting to do that a little bit in my writing. I realized I was using alliterative couplets to structure internal rhymes within my sentences. And then I was like, how many can I increase this to triplets and quadruplets while retaining the meter, flow, rhythm, and internal rhyme of my sentences? And then at certain points I was using like multiple alliterative triplets in like one sentence with an internal rhyme scheme, and I was like, I'm not really sure what it means that I figured out how to do this, but this is very adaptable and I'm having a great time. But yes, Hank Brennan should not write his motions in iambic pentameter. That's my conclusion there. And I know you watch these streams for these incredibly valuable insights, such as why should Hank Brennan not write his motions in iambic pentameter? But, you know. Well, at least I make myself laugh. This trial by media strategy has repeatedly been employed by the defendant and defense counsels for over 3 years. The Commonwealth is entitled to, and justice dictates, production of the defendant's own statements, particularly as proclaimed to be what exactly happened. Yes. In the defendant's various media interviews, she contradicts her own statements and makes admissions that the victim did not appear mortally wounded, that she thought she clipped and unknowingly incapacitated the victim. Further statements are likely relevant when compared to past statements. Yep. The defendant's statements are not hearsay and are instead substantive evidence admitted for its full force of proof. Nice. When a defendant deliberately undertakes a public relations campaign... Oh, this dry, sarcastic man. When a defendant deliberately undertakes a public relations campaign and saturates the public and the potential jury pool with statements likely to reach the potential juror pool, they also run the risk that statements may not be beneficial and may be incriminatory. That's Hank Brennan's very nice way of saying Karen Reed is a fucking idiot. The helpfulness or unhelpfulness of the statements does not direct legal basis for disclosure. The unaired statements made by the defendant and her counsels would be relevant and material to put the relevant aired statements, many of which will be introduced at trial, in context. Ooh, burn. Further, the absence of details provided in the unaired footage is fertile grounds for examination of witnesses at trial. Hank Brennan? Who exactly do you plan to call whereupon you're going to use unaired? Oh my God, you're going to call Alan. It's about Alan Jackson, Elizabeth Little, and David Yannetti. You're calling them in your case in chief with the full, and your intent is to get them to testify against Karen? I don't think this can go to trial. Ironic, right? With Josh Levy's words. But no, listen to me, folks. There is no way that Karen's lawyers, in light of what Hank Brennan is about to do to them, are going to let this woman take this to trial. No. Way too much liability for them. They might I don't think they can get out of having to testify there because they have it's not attorney work product if you broadcast a fucking documentary. Who agreed to this? Who signed a fucking contract saying that this could air unless there was a final verdict of some kind either way? Who agreed to that? Why in a million... Oh, got a message. Let's see if it's some kind of update about the trial. Oh, someone said they sent me a coffee. Thank you so much. God bless you. I appreciate it. It does not go unnoticed. I don't always read off. See, there's people who send donations and they don't go by that name, or like they used like a screen name that I don't know is connected to that name. So I don't always say, oh, thank you to this person, because it could be like somebody who either isn't commenting or whatever, and then I'd be like, oh, thank you, when they didn't send the donation. But I do want to say I do notice the donations, and if you send me a message after you send a donation, that's the best way for me to know that it was you, and then I will send a message to you saying thank you. If you don't, I will say thank you in a very general way when I see them pop up. And yeah, I guess that's one downside of not using the super chat system or anything like that. I can't really highlight in an individual way and say thank you to the people who are supporting this stream, but do know it like touches my heart. I think I said the other day, when I was like 17, one of my friends, as like a joke gift, gave me like a fuzzy steering wheel cover for one of my first cars, which was like a beat rundown minivan or something, which was good for adventures in high school, but it was, just a minivan. And I think my friend thought it was like, just a funny little like $2 gift or whatever. And I remember even like years later when I was like, like that was touching, and I like, people don't give me a lot of gifts, and so I remembered that forever. Like I don't think I still have it because I moved stuff around and whatnot. But I told him like in college or something when we were hanging out when he was visiting back from college. I said, I still have that steering wheel cover. I didn't have the minivan anymore, but I still have the steering wheel cover. And he was like, man, that cost me like $2. Like, I didn't even think about it. And I was like, yeah, but it wasn't the steering wheel cover. It was the act of you giving it to me. And like the fact that you thought, like, he was kind of like joking, he was like, oh, like, it's kind of funny because it's cold around here and like you'll have this like fuzzy steering wheel cover, like, whatever. Kind of like a towel, actually, which is funny in hindsight. But he was like, no, like I didn't really, like, I had forgotten about that, and it was like a $2 throwaway thing in my brain, and I was like, well, okay, I thought about it very differently, and the act of you giving it to me meant a lot. And I've always been that way, kind of like Dobby the house elf from Harry Potter. Like, if you give me like even like a sticker, like I'll always remember like you gave me that sticker. I think I got a blunt splitter one time with someone, like on a trip to Rhode Island. Like, they had asked me to like for some help or something. They needed to go like get vapes or from Rhode Island that were flavored or something, and then we like ran errands, and I got like a $1 blunt splitter, and like I still have that blunt splitter, and I will never lose it because it is an embodiment of that trip that I went on. And it's very sentimental to me. So anyway, when you send a donation like that's like $5 or $10, like that, like every one gets categorized in my brain, and I'm like, I just am completely overwhelmed. One time someone sent me like $50, and I was like, I almost like was like breaking down in tears. I wrote them a handwritten note, took a picture of it, and sent it, like made it into a PDF and then sent it to them. At the top it said like, from the desk of Grant Smith Ellis. Oh goodness. Wow. Nice little moment of levity there. I guess I can read some comments, actually, because before I go into the discussion of Brennan's argument for why he should get these statements from Reed's investigation discovery interviews, the full record of them. And we've already seen the full record of the Gretchen Voss interviews, although they weren't, the statements weren't in Voss's article, are damning enough. So who knows what this plethora of footage is going to be like from the interview that Karen did with the investigation discovery producers. Someone asked if we could build a Ken Mello statue riding a majestic steed. Ken Mello is an unsung kind of hero in all this, who definitely got the ball rolling on a lot of the evidence and prosecution related to Aidan Kearney. And I do think, along with Brennan and Special Prosecutor Cosgrove, he is up there, Ken Mello. And he's, from what I've heard over the past year from statements by Kearney's lawyer and other people representing the state in court, that Ken Mello's been very sick. I know he appeared at some hearings on oxygen, and like these like very like strange like bloggers would like make fun of him, like these people who like walk dogs for a living would make fun of Mello for being on oxygen. And I was just like, this is the low point of this case. Like, people who walk dogs for a living coming into a criminal case to do PR and mocking someone for being on oxygen at a hearing, just the lowest of the low. Someone said Amber Am. Yep. Someone said Amber Am. Yes. Daniel Donovan said this. TB will flip soon. He's got kids and will no doubt take a deal and testify against Karen. TB will be her undoing. Yeah. Hank Brennan has the power to offer that kind of deal. Jeff Williams says, thanks for all your coverage, Grant. Well, thank you, Jeff. I'm glad you're here. Kitty said, yes, Amber Am. Karen was definitely being herself. So revealing, eh? The mocking of Peggy. Damn. Jeff Williams says, the blogger is in big trouble. I agree. Mr. King of Kings says, I hope TB feels the same Oh, I'm not going to read that. Nunya Business says the mine work was high quality and family friendly. The mime work. I don't know what the mime work was. I hope Karen feels the same fear that John... Oh, no, I'm not going to read that. Let's see if the First Amendment helps TB now. Yeah, I don't think that's going to help him. TB is the absolute worst. Nunya says, I hope the Patriots draft Ginty at number 4. I have no idea what that means. Amber Am, Daniel, that's been my feeling. They got video evidence. Kearney's getting a minimum of 10 unless he flips. He could face 120. Yeah, I could see him, if Kearney actually got convicted, I could see him facing 5 to 15 with the number of charges there are. Trevor McIntyre, I agree. Let's build a statue of Hank Brennan. Yes, Hank Brennan walking with Ken Mello. With a turtle in a cage and I don't know what Karen Reed is going to be in. I haven't figured out that analogy yet. There was no snow under John's body. It happened early. That's exactly correct, Jeff. There was very little snow, which shows that John was hit around 12:31 a.m. by Karen's car, fell onto the lawn, and never moved. Nicole, Nunya, my King of Kings said Hank is very smart. I agree. Nunya says Napoleon conquered half the known world and he was small. Oh, was I talking about Gretchen Voss? Imagine Gretchen Voss conquering Europe as like a Napoleonic emperor. It's a little bit ridiculous, but I mean, weirder things have happened. Let's see. Very expensive attorney. AJ has been featured in other true crime documentaries. Yep, that's true. Let's see. Oh, wow, there's so many comments. You guys really enjoy engaging with these comments. Makes it hard to keep track. If I read all these comments, we'd be here for like an hour and a half. I just can't believe you all are so interested in this. I mean, I'm thrilled in some regard because that's really... like, engagement with the material is what I'm really most interested in. But I'm just actually blown away. I mean, wow, it just keeps going and going. There's so many comments. We're not even back to the part. If I tried to read all these, we'd actually be here until tomorrow. But listen, I'm committed to my craft. If I say that you can make comments and if I find them interesting, I'm going to read them. By God, we're going to do it. Let's see. The defense team, Snow Remover said, the defense team was disrespectful to the court yesterday. Any lawyer who agrees with them doing that is questionable. A lot of lawyers doing PR around the Reed case are questionable. Kitty says, how is it that they can directly sass and raise their voice, argue with the bench? What the heck? Were they trying to unsettle Judge? No, they were just being children. It's kind of like children fighting sometimes. Didn't you notice when Alessi and Brennan were going back and forth? Brennan even realized it. He was like, oh, I can't believe I'm getting in the mud and arguing about Alessi making false statements about me making false statements, which weren't true because I didn't actually make false statements. Like that, Brennan was like realizing he sounded like a high schooler, and that's what Judge Cannonian just kind of looks at them sometimes and is like, you children, even though Brennan's doing a very good job, when the defense starts playing its games, and if Brennan like takes the bait, she'll just kind of, she doesn't see it as an offense to the court. She's just like, my job as a judge here is to make you children get along. Like she'll even be like, are you two sure you can meet together? And in federal court, you'll even see some orders or some state courts where the judges will be like, I order you counsel to go to lunch and write me a report about your lunch and how you two can be nice to each other. Lisa Cox says, I'm new to this channel. Welcome. Good to see you. Jeff Williams said the dog is alive. Chloe is indeed alive. Someone said they should keep Chloe's name out of their fucking mouth. Well, we got to vindicate Chloe dog, so somebody's got to talk about Chloe in a good way. I mean, the Janet Reed versus Chloe dog subplot of this whole thing is very important in the sense that Janet Reed blamed the dog for no reason. Liberate Chloe dog. McLaughlin is very capable. Yes, Laura McLaughlin's an excellent appellate attorney, and she's excellent in the courtroom, too. They are terrified to face Hank in a fair fight. Well, Hank Brennan is on an unfair fight against Reed's team in the sense that he's way smarter than them, and he's outclassing them at every turn. Someone said Alessi is an attention seeker. When Alessi said 45 minutes yesterday, I was like, here goes the whole afternoon. Yes, Kelly, that's true. Amber said it was a joke about Alessi during the opening. He would put the jury to sleep. Yeah, I think he would. He's a good technical lawyer, though. Does he use himself as a sleeping aid? I listened to the Watergate testimony. So Senator Irving's excellent subcommittee on presidential campaign activities from 1972, which was like the precursor to the House Committee on Impeachment after the Saturday Night Massacre in October of 72, was it? And then maybe 73 was the Saturday Night Massacre, and then Nixon's resigned by August of 74. But needless to say, that series of hearings with the testimony from all of the different witnesses, Magruder and Howard Hunt and G. Gordon Liddy, that is the best way to fall asleep. I think it's permanently imprinted in my brain, like the entire history of Watergate down to like the specifics of every single witness's testimony, because I've replayed that in my before sleeping like 100 times. I listened to 3 or 4 things before bed. I listened to the Watergate testimony. I listened to a book called The People's History of the Supreme Court by Peter Irons, which is really, really, really good. It kind of contextualizes Supreme Court decisions in the context of wider socio-political developments. And then I also listened to tactical histories of Allied troop movements in the lead up to and during World War II. To get some understanding as to how political decision makers were reacting to the various pre-wartime and then wartime developments during World War II. All of that information to me is just exceptionally interesting. And then another book, if you're just listening to my recommendations as I take a break from reading the motions for a second here, another book that I listened to, an audio book on Audible that I think folks should listen to when they fall asleep if they want to become like my brain, which is apparently the result of listening to lots of audio books and consuming information all the time and not drinking or doing any social activities of any kind and going to school. The book about Ida Tarbell and Teddy Roosevelt that Doris Kearns Goodwin wrote, the Golden Age of American Journalism, the Bull Moose, that is a really, really good book as well. And then there's another really good book. It's like 89 hours that chronicles the history of the American Republic, like the entire history of the American Republic. And I'm forgetting that book's title right now, but I highly recommend that book as well. I truly believe if you consume that kind of material when you're falling asleep, just passively, it's not just like learning another language in your sleep, but it literally imprints the details in your brain somehow, both in the moments before sleep and I think even during sleep, because there is information in my brain that there's no way I should be able to recall. I don't use notes for these shows or anything like that. I just get up here. I have topics that I want to talk about, motions that I want to read through, and I know kind of what's going to come up in the motions, but I'm just letting my natural recall of historical events or case details or facts or motions or whatever it may be pop up as I'm reading naturally. And I'm certain that it's because this web of connections in my brain is being constantly reinforced by all of this information being fed into my brain while I'm sleeping and in the lead up to sleeping. That's my theory. I haven't actually studied it, but anyway, we're taking a digression because I'm reading through the second of 2 motions that were filed today in the Karen Reed case, and I'm reading through some of your comments, and then also I got sidetracked because people started sending very kind donations, and then I was overwhelmed. So trying to read your comments because you all are being so engaged, and what you're saying is very important, and also you're being very kind in sending donations, so I'm trying to catch up. But it comes with the price of digressions. This is a soap opera. I wish this could be fair, but defense are corrupt. Alessi has no idea. He seems like a sweet guy, but he's making a bad name for himself. Let's see. Someone said the case drives them crazy, but they come back for more. Lisa Cox said she feels bad for Colin Albert as well as the others. I agree. Easiest DUI murder case ever on video. Downing 7 to 9 vodkas, broken taillight, and I hit him. Guilty. Yep. A lot of people said smokers are taxed heavily in America. Yep. AJ yelling, constantly stopping around. Kelly said her child is able to control his emotions as an 11-year-old more than Karen at 45. Yep. Brennan is requesting all the footage from the documentary. Yes, no stray ants if you're just getting caught up. Someone said, you're so kind, Grant. Oh, I try, Lucy. I'm loving that Hank Brennan is getting the defense flustered. I agree. That's probably my favorite part of this tactical collapse of the Karen Reed defense. Snow Remover says, I feel like Karen has turned her team into scorned women. That's your perspective. None Your Business said Karen should do an interview with an anonymous person and then Hank can't find them to ask for it. Don't give her ideas. What the fuck? Where is her hair? That must have been from the picture I put up. Lisa, what are your thoughts on the third-party culprits? I wouldn't say they were accepted by the court. Is that motion? I don't think that motion's been ruled on. That's just what Yannetti's trying to argue. The female Charles Manson. Sorry, Hank. Sorry, Hank Brennan. The interview was in international waters, like that episode of The Simpsons where the monkeys are fighting with knives on a boat, and the sea captain's like, we're 12 nautical miles offshore," and the U.S. government's shaking their fist at the sea captain. Oh my God, that would be a good meme. Karen Reed on the Simpsons boat in international waters. Being like, you can't get me here, Hank Brennan. I think if Karen Reed got on a boat and tried to go to international waters, they'd probably arrest her. Like, the state police would probably literally arrest her on the way out to international waters. They would interdict her. Coast Guard, we have a fleeing Karen Reed. We need you to interdict. Foxtrot Tango Alpha, scatter the fighters from Joint Base Cape Cod. All right. Why does an adult man call themselves a turtle boy? That's a very metaphysical question. I can't answer that. Someone said Turtle has ruined his life for a total stranger who is accused of murder. What a moron. I mean, if Joe Biden had been reelected, I don't think the federal probe would have been confirmed as closed. I think the reality is TurtleBoy just had connections to like Rachel Rollins, and TurtleBoy's like a political operator. I don't think he's actually, I think he's a Republican in name only. He's actually a rhino in my opinion. Like I think TurtleBoy is closer to like a moderate Democrat. Like, I'm pretty sure TurtleBoy's articles led to the conviction of a January 6th rioter, you know? And it makes me wonder, like, did TurtleBoy, like, have problems with what NSC 131 and Resist Marxism and Boston Free Speech and whatever was doing? I don't know. Certainly would change people's perspective on TurtleBoy. Like, I don't think TurtleBoy is what you think he is. You know what I'm saying? I think he's closer to like a law enforcement source than an agitator. That's just cover. Don't you all see it? Let's see. No way 30 people are involved in a cover-up. I agree. If Richard Nixon couldn't do it, nobody could do it. And the only person who tried here was Karen and the DOJ and TurtleBoy, and it failed. Take Karen out of it, and how do you guys feel about the morality of D.A. Morrissey and his trooper squad? Birchmore case alone, very telling about their behavior, but it doesn't go to the Karen case. So I don't think it helps Karen, but yeah, like in some ways, I think people see Karen, like, especially people who are like, all cops are bastards, like, which, by the way, is a mentality I really don't agree with. I went off on this the other day. I think it's outrageous that people believe in this mentality of all cops being bastards. That's absolutely ridiculous. Very important role that cops, firefighters, court officers play in our society. And if we create this mentality that a few bad apples literally mean every single person who works those jobs is bad, then we will create a situation where it's a self-fulfilling prophecy, because those people will become jaded and upset and come to believe that people actually hate them, and then they will start acting that way. It will become a self-fulfilling prophecy. So I hate people who say that about police, but that's why I think it's so weird that a lot of these right-wingers, Republicans on the ground, like TurtleBoy fans, don't see that, like, the origin of the federal probe into John's death was just like Rachel Rollins' hatred of, like, cops. That's what I think it was. And Rachel Rollins' hatred of Michael Morrissey, which of course traces back to this dual bifurcated tension that Rachel Rollins and Michael Morrissey had. One, because Rollins was like the opposite of the broken window theory of prosecution. Like, Rollins wouldn't prosecute any low-level offenses at all. She would just null-pros them all. And other DAs commented on that, and that pissed her off. And she saw, I think she called Morrissey a meatball or something. Like, she was really offended by Morrissey intervening on her turf. And then there was this big split. Morrissey and some other DAs tried to intervene in this case where Rollins wanted to alter how youthful offenders between 18 and 21, I think, maybe 18 to 25, but somewhere in that range, were sentenced if they committed murder. She wanted to remove life imprisonment as punishment for murder, and that caused Morrissey to try to intervene in the case. That caused more tension between Rollins and Morrissey. And then Dustin Chow, who was working as the head of the public integrity section under Rollins at the time, also had his own history of tension with Michael Morrissey, dating back to 2015 or so, when there was a situation where Chow's wife was passed over for promotion during a joint prosecution between the U.S. Attorney's Office and the Norfolk DA. Not really a joint prosecution. It involved Whitey Bulger, Stephen the Rifleman Flemmy, and Frank Cadillac Salemi. And a murder had taken place in Sharon like 25 years ago, 15 years before that point or so. And murder is in the original jurisdiction of the state police on the whole, and so the only way in that case that the U.S. Attorney's Office could federally pursue the case, which needed to happen because there was a lot of federal informants involved in the Bulger gang case, was to get the state police to give up jurisdiction, which they did, and so the U.S. Attorney's Office and the Norfolk DA worked closely on that 2015 Bulger case. The murder was in Sharon or something. And the implication of all of this is that while that was going on, Dustin Chow's wife gets passed over for promotion in the Norfolk DA's office, leaves on bad terms, and Chow then goes around saying he wants to do whatever it takes to burn down the Norfolk DA. So you got Chow 7 years later, you got Rollins a few years fresh off her battles with Morrissey, you got Karen Reed and her attorneys walking in to Josh Levy's office in November of 2022, staging this grand conspiracy. But really what I think Yannetti was pitching was, listen, Josh Levy, you guys are going after the state police and these cops. We think that this is a good way for you guys to find out information about these cops. And inevitably, the investigation into John O'Keefe's death was closed with no charges or indictments of any kind, right? But I do think that federal probe and Karen's push to get this whole situation looked at is what in turn exposed the Sandra Birchmore cover-up, and then also brought to light this DOJ once Leah Foley came in as the new U.S. attorney. I think it also exposed the DOJ playing some tricks in another Bulger-Conley situation, popping up like with Dick Layer's Black Mass, Dick Layer and Jared O'Neill's Black Mass, wherein Reed and her team were given a wink and a nod by the DOJ to engage in all this behavior with Kearney, too, as to the witness intimidation and leaking federally protective documents and smearing all the witnesses. And it was because, one, there was a grudge to go after Morrissey, so fuck it if Morrissey gets, rumors spread about him. That's how Rollins and Levy and Chow would have probably thought about it. And then also, it's good cover to bring in. It's like a honeypot, brings in tips about the state police, and then they stumble onto Birchmore. So there's a lot, and that Birchmore probe goes from August 2023 until Farwell gets indicted in 2024. And obviously, there's no way the state police could have signed off on Sandra Birchmore's murder being the result of self-harm, and then the feds quickly discover it was murder, right, without the state police having covered it up. There was very obvious evidence. And we don't know where that's all going, but it certainly makes sense why Josh Levy would want to give a wink and a nod on two different levels to Karen Reed and her team to let them smear Michael Morrissey and the Norfolk DA, and then at the same time weaponize the pretextual federal probe as cover to keep the Sandra Birchmore investigation quiet. A lot of people focusing in just the right ways on the Norfolk DA and that unit, but without compromising the Fed's ongoing probe. And then also, there's one more element that plays into all of this, which is the proxy battle between the Norfolk DA and the DOJ, and the way in which the DOJ goes about running these operations to investigate people is very similar to how the state police would investigate someone, and there's a lot of reciprocal tactics, and so these sides know each other very well. And then the third element about this proxy war that really, I think, explains why Karen Reed was able to pull this off is... Oh, no, I was actually going to explain why Leah Foley coming in, and to tie this back, why Biden losing the election to President Trump is actually what kind of sealed this deal, because I think the old DOJ would have continued that Self-Preservation Act, let Karen continue to weaponize this federal probe and whatnot, but the new DOJ is much less obviously like all cops are bastards. Like, no way the new DOJ buys that stuff. And so comes in, Leah Foley orders the release of the previously hidden contacts that occurred and payments during the federal probe between Reed and ARCA. That's what I was going to bring up. I think Josh Levy and his team knew, Adam Deutsch and whatever, knew about the ARCA payments and contacts, knew that it was being withheld from Judge Cannoni, and that was behavior was given a wink and a nod by Josh Levy as well, to try to ex post facto be like, well, see, there was some semblance of justification for us to have run that federal probe just to cover his own ass. But Biden loses the election, President Trump comes in, Leah Foley's like, what the fuck was Josh? This is what I believe the new U.S. attorney would have thought. What the hell was Josh Levy and Rachel Rollins and Adam Deutsch, what were they all doing with this outrageous case? And then out of nowhere on January 30th, 2025, you get this random disclosure from the DOJ in Boston to Hank Brennan after lots of unsuccessful TUI requests from Brennan under the previous DOJ. You get this random January 30th disclosure showing just this snippet, just a letterhead of ARCA, some kind of invoice to Reed's team. That's enough. As I've said before, if you've watched the movie V for Vendetta, there's a scene where the main character and a woman named Evie, who he saved from this totalitarian dictatorship in the film, they're in this cave underneath the ground somewhere in London, and Evie is the woman's name. She says to the main character V, why did you have to keep me here for so long? And V looks at her and says, well, do you see the rocks in the wall, the stone, the color? That is enough for a smart person with you under interrogation to figure out where we are. And that's what I think the DOJ did with Hank Brennan releasing that little snippet. They knew that a smart man could figure out, just from the color and type of the wall, a location underground, and indeed a smart man from just a letterhead could figure out what had been going on with Reed and ARCA's defense. That was a lot to explain. Someone said they were glad Hank visited Chloe Dog. We're going to have to skip some of these comments. There's just so many of them. Ropes and Gray Law Firm, where Josh Levy worked, does have a relationship with Bentley University, where William Reed was dean. Yeah, I asked Mr. Reed last summer if he knew Josh Levy. He said no. He could have been lying, though. I think it's more likely it was David Yannetti. David Yannetti was on Rachel Rollins' transition team when she became Suffolk DA. And then also David Yannetti was definitely, I think he knew Josh Levy too. And also, don't forget, TurtleBoy knew, don't you all think it's a little weird that TurtleBoy knew Rachel Rollins? TurtleBoy and Rachel Rollins met and were talking, despite ostensibly being enemies with TurtleBoy critiquing her, all the way back, former U.S. Attorney Rachel Rollins, all the way back when Rachel Rollins was Suffolk DA. TurtleBoy and Rachel Rollins were talking about sending a spoiler candidate named Rayla Campbell, a Republican, into the Senate race in 2020 between Joe Kennedy Jr. and Ed Markey. And I am just convinced, this prescient, informative, sentient towel that I am, that Rachel Rollins and TurtleBoy sent Rayla Campbell into that race to go after Joe Kennedy because the Biden White House wanted Ed Markey to win that Senate seat so Joe Kennedy Jr. wouldn't go from the House of Representatives into JFK's old Senate seat and then in turn into a presidential primary against Biden in 2024. That in turn explains why right after that, the Biden White House appoints Rachel Rollins to the position of U.S. Attorney in Boston, a position she gets fired from, basically forced out of, in just like 18 months for launching pretextual federal probes against her political opponents and leaking them. You know what I mean? And that's literally what, like, it's been staring us in the face the whole time, folks. Rachel Rollins ran this playbook on Kevin Hayden after Ricardo Arroyo lost in the Suffolk County DA primary, and Rollins was mad at Hayden for beating Arroyo. They were both Democrats, but Hayden was appointed to fill the seat that Rollins left when she took the position of U.S. Attorney by then Massachusetts Governor. So Rollins was appointed by President Biden, but when Rollins left her seat as Suffolk DA, the way the law works is then Massachusetts Governor Charlie Baker, who was a Republican, moderate-leaning though he may have been, was able to fill the Suffolk County District Attorney seat. Well, Baker filled it with a Democrat, Kevin Hayden, who's moderate, and that really pissed Rollins off. So she tried to help her ally, then Boston City Councilor Ricardo Arroyo, run against Hayden in the primary. But there was all this shit that came up about Arroyo, like right in the lead up to the primary. It was way more than this, some NBTA thing. I think there was like pretty serious stuff that came up, and that he did not win. And so as a result, Rachel Rollins launched a pretextual federal probe into Kevin Hayden. Same exact thing happened with Michael Morrissey, in my opinion, by way of the John O'Keefe federal probe, and then there just became all these other motives that it layered on to why there was incentive to cover it up by the DOJ. Yeah, Ropes and Gray is still listed with Bentley's career edge. I think, so Kimmy K says, I think Hank put AJ and DY on the witness list so he could question them about their interaction with TB from the phone logs. Yeah, definitely, I agree. I also think it's about questioning them about what Karen said to some of these news interviews, because there's no privilege if you say things to a lawyer or in front of a lawyer with a third party there. Let's see. Karen keeps adding little tidbits to her story. Someone said, oh my God, for real, can't stop smiling. Someone said, did you see the final motion that was approved yesterday? Yep, the one for TurtleBoy's phones. Yep, I did hear Alan Jackson say before the collision. Exactly, that was a Freudian slip. Karen and John fought more, had makeup set, fought more, etc., and carried it on until she ran him over and left for dead. Oh. Kimmy K, so now Hank can get TurtleBoy's phones? Yep, that's right. Hey Grant, can you touch on what your show last night was about? It was a 6-hour review of the motion for TurtleBoy's phones, and then we also went through the affidavit for Karen's cell phone search warrant, and then we looked at all the evidence, like 31 pages of how Lindsay Catani in the fall of 2023 had evidence that Aidan was saying to Lindsay that Karen and Josh Levy had a direct connection, and that Josh Levy was releasing information to Karen about the federal investigation in a weaponized way that Karen was relaying to TurtleBoy. And then we also read about how in the summer of 2023, between April and June, there was another intermediary involved. There was an intermediary involved between Karen and Aidan named Natalie, and Karen would send messages to TurtleBoy through Natalie. And we learned about how that evidence is most certainly what Hank Brennan's going to uncover. Also, if you're wondering why your questions don't get answered right away, it's because I get a little bit backlogged in the chat. Yeah, it did take a long time to get through the phone info. It was like 5 hours. All right. There's so many comments. Let's see. Miss Little Laurie sounds like a nervous wreck. Yeah, but she doesn't argue a lot of motions. She's getting trial experience. Someone said, Grant, you are so funny. I just try to do what I can. And someone's laughing. I don't know what I was saying at that point. I'm almost caught up with the comments, though. Let's see. Yannetti was so mad yesterday, too. Someone said, love you, Grant. Oh, thank you all. And Towel loves you all, too. We do need the levity. All right. Let's see. Great show. Oh, yeah, we're almost done. All right, there we go. So many comments. I know a lot of people read the comments at the end. What I try to do is read the comments to take a break from the motions, but we will get back into the motions now. Pursuant to Massachusetts Rule of Evidence 801D2A, I like 801D2E. The Commonwealth seeks to introduce multiple statements. Oh, so it's the hearsay exception for when statements by a defendant aren't hearsay because it's by the defendant. Pursuant to Massachusetts Rule of Evidence 801D2A, the Commonwealth seeks to introduce multiple statements made by the defendant. A defendant's statement is not hearsay and is in, well, it's just one of, I guess 801D. Oh, so 801D2E is just things that aren't, and D2A are just things that aren't hearsay. So it's just not hearsay and is admissible against the defendant. Like it seems weird to think about it this way because there's like 28 hearsay exceptions, but then there are things that are just not hearsay. And the defendant's statement is just not hearsay. And it's admissible against, because it's a statement by a party opponent. And it's admissible against the defendant when the statement was made by or adopted by the defendant. See Massachusetts Rule of Evidence 801. Statement includes a person's oral assertions, written assertions, or nonverbal conduct if the person intended it as an assertion. The hearsay exemption for statements by a party opponent encompasses any extrajudicial statement made by a party opponent, not just statements that are inculpatory or against the party's interest. Oh, okay. The defendant and her counsel cannot avail themselves of a media strategy to publicize and promote the defendant's varying claims to the public at large and the potential jury pool, while simultaneously excising statements and admissions that may not be favorable to her cause. Huh. All right, so let's take a look at this case, actually. I'm very interested in this. What I like to do is when Hank Brennan actually cites a case, this is not a very case law heavy motion until now, but we finally have a case. Commonwealth v. Conzubal, 488, Mass. 575 is all we need. The pin site's 584, 2021. All right, so I found that one. And then let's find Commonwealth. Yeah, I understand. Commonwealth v. Spencer from 465 Mass. 32, 2013. So let's find out what Hank Brennan is talking about here. All right, so I have these cases for you. They're not exactly the easiest thing to find because Mass Cases forgot to renew its, but anyway. All right, I have these two cases. We are going to read them together, and we're going to figure out what exactly is going on. All right, thank you. All right, I'm going to bring them up on the screen for you now. Give me 1 second here. All right, we're going to start with Commonwealth v. Conzubal. Here it is. There it is. I'm just going to put it over my whole screen. All right, so you can see here, this is, and what are we looking at this case for? We are very deep in this motion, and we are looking at this for the purpose of whether just what type of statements made by a party opponent, in this case the defendant, can be used against the defendant. All right, let's see. So this is about hearsay admissions and confessions. All right, and we're looking specifically for the statements. All right, now admissions of text message between defendant and victim. He doesn't argue authentication of the text message, but instead argues that some specific text messages were inadmissible hearsay. Conversely, the Commonwealth argues that the omissions of the text were proper under the hearsay exception for this is what we wanted, for statements by a party opponent as well as to show the defendant's state of mind. We agree with the Commonwealth. Oh, yes, Hank Brennan. Yes, you genius. You wonderful man. Let's figure out why Hank Brennan's going to win by citing this case. The Commonwealth moved to allow portions of the defendant's extensive text conversations with the victim. Specifically, the Commonwealth sought to introduce all messages from June 24th to July 11, 2016, as well as messages discussing the defendant as a teacher or mandated reporter, discussing the defendant's request that the victim delete certain messages, discussing the defendant getting in trouble for the relationship, or telling the victim not to tell anyone about the relationship involving flirting, and discussing the victim's age. The defendant moved to exclude the text messages on hearsay and relevance grounds. The text found the text from the defendant admissible as a statement of a party opponent. The judge found the text messages from the victim to be admissible under the doctrine of verbal completeness to render the defendant's statements comprehensible, to show the relationship of the parties, and to show some of the defendant's text messages were adoptive admissions. Huh. Additionally, an extrajudicial statement made by a party opponent is an exception to the rule against the introduction of hearsay and is admissible unless subject to exclusion on other grounds. Commonwealth v. Spencer. We're going to read that one too. The hearsay exception of the party opponent encompasses any extrajudicial statements made by a party opponent, not just statements that are inculpatory or against the party's interest. Spencer, supra. Finally, statements may be admissible under the hearsay exception of adoptive admissions. So we don't need the adoptive admissions. We want to go to Spencer. That's where we're going. You see what you have to do sometimes? And I know a lot of people are like, yes, it requires formal training to do this, but like, how is he doing this? And it's because first of all, I'm not a lawyer or your lawyer or anyone's lawyer. I'm literally a towel. But the other thing is, it's a matter of just doing it over and over and over again. So what I'm doing here is I'm just tracing through. We're starting in Hank Brennan's motion for the records to motion for records from HBO related to Karen's interview on ID Discovery. But now we're 3 cases deep in precedent because we're looking at whether Karen's statements as like a complete record or just the inculpatory part should come in. And we find these 2 cases, the one we just went to and now Spencer that we're going to look at now, that show that you can get the full record of statements by a party opponent, in this case the defendant, whether they're inculpatory or not. So we're going to read this. Let me open my second Gatorade. Some people play video games to relax. Some people watch movies. I like to do multi-hour live streams and break down complex court motions and drink Gatorade. No caffeine for me today, though. I only had my initial Dunkin's iced coffee at like 5 in the morning or so. So imagine some days when you all see me, it's because I've had a second coffee drink or like an energy drink, and if I have one of those energy drinks with taurine and caffeine, that's when you get those detailed, layered Joycean, Hegelian explications of history's beautiful syntactical form. On days like this, you just get dense readings of case documents. All right, here we go. So we need to go to the part about statements by a party opponent. Looks like this is about a drive-by shooting. Here we go. It's because the defendant made 8 recorded telephone calls from the Worcester County House of Corrections. Let's see. What type of things was this person saying? why Cisco is telling everyone stupid shit when he should be holding me down. Cisco confirms that he will hold the defendant down. Ah! I love this. Call 10R. The defendant tells Jenska that he needs her to do something for him and that he cannot even say it over the telephone. He tells her to take something green from the back hallway and give it to someone whose name is not discernible. The defendant calls Janeska. The police reads her the police report summarizing Tito's allegations to police. He notes that there is no ballistic evidence. Jessica says that the defendant will be fine because he knows he had nothing to do with it. The defendant suggests that he intends to post copies of the report in various restaurants and businesses around town so that people will know Tito is a snitch. Jenska supports the plan. Cisco then joins the conversation in a conference call. He says he is holding the defendant down and that all kinds of rumors are circulating. The defendant says there is money on his head. Cisco says the defendant should not worry about it because the defendant knows he was at his baby's mother's house at the time of the shooting. It doesn't even put it in quotes. The defendant speaks with Cisco a few minutes later, again in a conference call. The defendant says there's a $50,000 price on his head, but Cisco thereafter dominates the conversation, saying the police questioned him and he told them nothing, and then detailing the alibi he gave police concerning his own whereabouts. Police are acting as nothing to worry about. Jenska says she doesn't want to be with the defendant anymore. After talking to someone named Brianna. Oh, he denies cheating and wants nothing to do with Brianna. They call Brianna, but the defendant refuses. The Jenska maintains the defendant has been with Brianna for a month. The defendant calls Jenska, and I've identified male joins the conversation. I'm talking about like breaking windows and all that other shit. And the defendant responds, yeah. What the fuck? Take the ones that got stepped in. Wow. All right, so here we go. The motions were denied by judges. He tried to suppress the statements. The judge found the statements were made voluntarily after Miranda warnings, not coerced, no reasonable expectation of privacy. So we're not looking at all of that. We're looking for the part about them not, like all of them coming in, not just the inculpatory ones. All right. Misapplied the rule regarding statements by a party opponent. Right. So it looks like the trial judge ordering portions of the 3 interviews and 6 of the 8 telephone calls be excluded because they constituted police accusations and they were not relevant or they were substantially more prejudicial. So it looks like this issue is whether all of them should have come in or just some of them. So this is the key issue here. And obviously he's gone for all of their, like, all records before from some stations, but I think this is a fight. Like, I think HBO or Investigation Discovery is refusing. So Brennan might actually have to fight this, and I think the case law, based on what we're reading here, in my lay opinion, goes in Brennan's favor. Because what I'm seeing here is that the Commonwealth appealed that ruling via 211.3, and the single justice granted the petition, and the Commonwealth got to file an interlocutory appeal after the lower court proceedings were stayed. Then this court considered the referral from the single justice. All right. The Commonwealth contends the judge confused the concept of admissions by a party opponent with declarations against interest. Yep. All right. We need the actual decision. Here we go. Although focusing on whether a statement is an admission inculpatory would be improper in determining whether a criminal defendant's statement is admissible as a statement by a party opponent, the judge did not adopt such an analysis. The judge held whether or not the SJC has rejected the broad use of any statement by a party opponent that it's suggested by the rule is for that body to articulate. Oh, this is great. This is the case. The admission, okay. The Commonwealth essentially takes the position that with minor exceptions, it should be permitted to induce the recorded interviews and the 8 jailhouse calls in their entirety. It agrees that incidental references to drugs should be excluded, and that statement made and posed by police should be admitted with limiting instruction. Standard of review. All right. Well, this is a long ruling. All right. What section did Brennan quote from? One-sided statements. There's a very specific part of this case that Hank Brennan quotes from that is what I'm looking for. And it is the part where they're talking about how not just the statements that are inculpatory. So I'm going to search that word. Here it is. Although often referred to as the rule on... I found it. E, page 46 of the ruling. Statements by... Oh, this is a long ruling. Statements by a party opponent. An extrajudicial statement made by a party opponent is an exception to the rule against the introduction of hearsay and is admissible unless subject to exceptions. Although often referred to as the rule on admissions by a party opponent, it encompasses any extrajudicial statement made by a party opponent, regardless as whether it is inculpatory or against the party's interest. And the reason why it was so hard to find is that the actual site is Commonwealth v. Cutts from 2005, which is this case. And I was looking through that whole case, and I was like, this is not what we want. But it was citing to another case. And the reason why this is important is this is going to determine if Brennan gets the whole record from HBO, like this specific line of cases, because of the nature of the fact that Brennan's not limited to just inculpatory statements. So that's what we're going to look for here. All right. All right, here we go. Weldon's testimony that Cutts stated murder one, and told Weldon that he had been through this stuff before was also admissible. Any extrajudicial statement by a party may be admitted as evidence against the party by an opponent and will not be excluded on grounds that constitutes hearsay. Interesting. What line am I looking for again? What line is it quoting? Regardless as to whether it's party's interest. Party. Here we go. Found it. So it's literally quoting another case, which is Commonwealth v. Lewin, which is Commonwealth v. Bonami. So this is old law. So it seems like it goes back to 1956. That's why it took me so long to find. It's not. This is the actual. This is the actual opinion. All right. This is where the rule came from. It probably uses very old language. All right. All right. Yep. This is actually a little bit tough to read because the language is from 1956. Wow. They would just make rulings line by line by line. This is very hard to read. But that's so interesting. That's where we get a lot of our precedent. They would say things like, at the trial of a defendant for murdering his wife on a certain day at a specified time, testimony of certain witnesses as to what they had seen at the time in front of the wife's home was competent, although they were then passing by her home in an automobile. Like, that's a full ruling on an issue in a sentence. I wonder if that's just how it was done back then. So what we're really looking for is like the word statements. Yeah, here we go. So it looks like it doesn't matter whether they're inculpatory. Oh, this just keeps going and going and going. Those must have just been the head notes. So it looks like it doesn't matter if they're inculpatory or not. They can come in. Yeah. All right, so this looks like a pretty solid line of case law from Brennan here. I don't really see any chance that Brennan doesn't win this motion, but what it will come down to is whether he's entitled to the full record. And so if you want to know, it's not easy to trace it back, and Hank Brennan didn't actually take us all the way back to 1956, but that's where it came from, this concept of the exception to the hearsay rule for statements by a party opponent is not limited just to inculpatory statements, and therefore Brennan can get the whole record. The defendant and her counsel cannot avail themselves. Oh, we already went through that. Furthermore, under Massachusetts law, it is well settled that news reporters do not have a constitutionally based testimonial privilege that other citizens do not have. This was what Gretchen Voss tried to argue to protect her records at first. There isn't really a privilege. What I'd call is there's like a very narrow exception. If you can show that like you're being subject as a reporter to like torment, like if like people because of your coverage are tormenting you, you know, like bothering you online, like whatever, there's a limited, and maybe like tormenting your family, whatever, there's a limited narrow exception that was recognized by Judge Kearney when ruling in Voss's favor during the first Karen Reed trial. But, and I want folks to understand, HBO, maybe they're in a state or something, or ID Discovery, where there is a reporter's privilege. The privilege does not exist here for the most part in this context. Some stuff, like off-the-record stuff, has been shown to survive a Rule 17 challenge. Some, like explicit off-the-record conversations have been shown to survive a Rule 17. Oh, someone else sent a donation. All right, I'm going to read that one too. Hold on. That explicit Rule 17 stuff has been shown to survive. Explicit off-the-record conversations has been shown to survive a Rule 17 challenge under, I wouldn't call it a theory of reporter's privilege, but under some kind of like Lampron Rule 17 analysis, okay? Now, this is a little bit different here. This is a situation where we are talking about on the record conversations, because clearly the material was used in the documentary. And the only exception there, and even then it didn't hold up for Gretchen, because Judge Kearney ended up saying that Gretchen like attended some of the days of the trial, and so therefore like her arguments about like the like not being able to turn over or not being forced to turn over records because she was suffering like undue harassment or whatever just fell apart. So actually, that's the answer to the question. If people are wondering why, sorry, I'm putting my microphone down to roll this tobacco cigar. If people are wondering why Voss is why Voss is on the witness list and all of her, way more of the conversations came in with Jackson and Voss, it's because during the first trial, Voss was able to plausibly argue that she was being tormented and in fear. But then once she started attending hearing days, Judge Kearney couldn't use that, would not give her the benefit of the doubt there, ordered more of Voss's recordings in. The only thing that didn't end up coming in was some of the off-the-record stuff, and therefore way more information was given to Brennan. Now, this is important here because if there is an objection from HBO, they are allowed to assert all sorts of objections and privileges and whatever they want. Hold on one second. Where's my lighter? They're not going to actually win on the assertion of those privileges, but they have a right to assert them. And I can't believe I dropped my lighter. Part of the reason why this is such a convoluted issue is because what HBO will be, they won't win on this argument, but what they'll be able to argue is that there probably is stuff in there, and this might actually cause an argument. I don't know when we're going to hear this motion. I would guess it will be next week. But there is definitely going to have to be some discussion. Hold on one second. There's going to have to be some discussion about what exactly the scope of the conversations were between Karen Reed and this documentary. Because if the HBO really wants to object to this, if there's material that was actually off the record, then HBO is going to actually have to say that. Gretchen actually had to go onto the record and make an argument in a formal court motion that she was unable to comply because of the nature of the off-the-record conversations. But that itself will tell us really all we need to know, in my opinion, about what's going on with Karen if she's forced to say that, or if the HBO documentary people are forced to say that they have material that is off the record related to their conversations with Karen. Because I don't know if you all remember, but it was as a result of Gretchen Voss saying that Hank Brennan was able to get all of those off-the-record conversations. Although they couldn't be used, he was able to get them reviewed by Judge Cannoni. And I'm sure that is partially what weighed on Judge Cannoni's decision related to permitting Hank Brennan to get some of the on-the-record conversations that he had previously not had access to. My lighter fell into a crevice between my desk and the floor, and now I'm frustrated. Ugh. Just my luck as I wanted to move on to smoking my next tobacco cigar that I would misplace my lighter. All right, but that's all right. Let's get back to reading. Oh, that's so exceptionally frustrating. Now I can see why when people do these long live shows and just like they'll either like get up to like go get like food or something will happen, and I'll be like, how does something like that happen? And now I absolutely realize how it can happen. Hey, I got it. All right, I'm back. There I am. Okay. So let's get back to reading. And I think I was spending my whole time there talking about how reporters' privilege could play in here because, and there might, I don't know if there's going to be a delay. This is very material. This actually could cause a delay. Maybe we'll deal with it during jury impanelment, but this could cause a Rule 17 fight because this is the first time like HBO or ID Discovery actually has an opportunity to be heard on this. I mean, I guess, yeah, Gretchen's lawyer had standing, so they get to be heard, and if they object or assert privilege or something, which we'll probably find out next week, it could introduce this procedural hiccup where they have to say on an item-by-item basis, this conversation that we recorded with Karen was off the record, or we didn't record this conversation, but we took notes and it was off the record. This stuff was on the record. This stuff was on background. They might do that. They might clearly, we're going to get to the end of the motion, the HBO producers or the ID producers say, we are not going to comply with this. So it makes you wonder, why don't they want to comply? They hit Karen pretty hard in that documentary. It was not very flattering to her. What else do they fucking have? And what are they saving it for? Because obviously Gretchen, there was some stuff she didn't put in her article that was very much on those recordings. And Brennan's using them. This is a whole masterclass from Brennan in why defendants should not talk to the media. Hold on, though. I promised I would read this donation, especially since I found my lighter. Oh, that's so kind. Someone sent a donation, and they included a very nice pizza emoji, and I might actually get some pizza. And I just want to say thank you to the person who did that. I'm very grateful, and yeah, make sure to get either two. I get 2 slices of pizza from 7-Eleven for $1.50 each. So the next time I go get my pizza tomorrow, person who sent that very kind donation, just know that I will be thinking of you. All right, let's continue. In Massachusetts, there is no qualified journalistic privilege that protects against disclosure of confidential and non-confidential press material. Even if such privilege did exist, the parties seeking disclosure of non-confidential materials are entitled to seek discovery from a media entity if they can show that the materials at issue are of likely relevance to a significant issue in the case and are not reasonably obtainable from other sources. Yeah, and I think that that precedent's already been met here. Judge Cannoni has issued a lot of orders for these type of Rule 17 subpoenas to media organizations. Most of them just comply. They don't even bother waiting for a ruling. The only person who has really fought it was Gretchen Voss, and even then, even though she won the first trial, she did not win the second time around, and she only barely got out of there with not having to disclose her off-the-record conversations with Karen. And I think that was a big win, even at that. But yeah, there is a pretty firm precedent, and these orders issue quite often. So I'm not sure what ID thinks they're going to fight here. I'm checking the docket again for you, by the way, because it's about 4:30. All right, here we go. We have some dockets that went up. The defendant's amended list of prospective witnesses, and a general correspondence regarding jury questionnaire. All right, let's find them together. Hold on one sec. I'm going to see if I can get you all this motion. I imagine Dee Dee or someone put it up. Who you want to put on your witness list now, Karen Reed? Let's see. Witness list? Come on, Dee Dee. What? No witness list? What about Dag Nabbit? Anybody? Hello? Nobody? I guess it's coming to the end of the day, but still, I expect normally the documents go up right away, especially when it's in a defense amended witness list. Hold on. I also saw that someone made a comment that said, Hank Brennan just said new text stream data shows time and place. Yeah, if it shows Karen going to Fairview Road at 5:23 a.m., she's screwed. Let's see. Come on. Where is this defense updated witness list? I imagine it normally this is, unless it just went up. Let's see. I guess I might be able to just search witness list on Twitter and just see if anyone has used the word witness list in the past 10 minutes. Oh, 47 seconds ago. Are you watching this stream? Sometimes I think some of you actually watch this stream, see it here or hear it, and then go off onto Twitter and be like, someone's got it. You know what I'm going to do, since I actually technically saw it first? I'm going to take a screenshot of my phone, and then I'm going to send it to myself, and then I'm going to make a post about it. And I'm going to be like, join me live when I get a copy of this defense witness list. It is somewhat, it is definitely telling, though, that there is this effort by the defense and prosecution to keep updating their witness list, though. Don't get me wrong. There are more bombshells to come in this case. I'm really intrigued, actually. I'm glad you stayed with me, because that defense witness list and the general correspondence regarding the jury questionnaire was the last things that went up right before 4:30. And I'll normally try to do these streams either after close of court, or if I start, I'll talk intentionally until the close of court, so that we can see any updates that go on the docket. So, as we're waiting for this document to go up, sometimes I will literally just say things on stream like, Dee Dee, shouldn't you get that document? And then somebody, like, all of a sudden it'll just pop up. But while we're waiting, I'm going to continue reading through this motion, and then we're going to be able to review the defense's new witness list, see if they added anybody. Who is it? Oh, hold on. Let me take this call. I know, you're all so intrigued. I'm sorry. You're not getting anything out of me. You're just going to have to deal with it. All right, here we go. All right, so I'm waiting for the defense witness list, and then once that goes up, I'm going to try to read that for you, and then we're going to get to the end of this motion, and then I'm going to be done for the day because I have things to do now. Look at how that is. Look at how life plays out. All right. So I'm downloading. Let's see if we can get this defense witness list. It can't take that long for it to go up. It's so funny that when I searched defense witness list, the only thing that came up was the one person who probably was listening to this stream and was like, anyone have the defense witness list? All right. Let me put up this post 1 second. Let's see if we got. Sometimes we get the document, but this was a very late file, so if we don't get it, you will definitely get the chance to read it from me when it goes up. Yeah, nothing left. Excuse me, nothing. Nothing on the docket just yet, or nothing sent for. Sometimes they promulgate, the court promulgates the media files, the files to the media when they go up, but this is a late file right before the end of the day. Okay, let's continue. The records are not otherwise obtainable, not held in the care, custody, or control, and the entity will not produce the records without a court order. The Commonwealth cannot properly prepare for trial without such production and inspection in advance of trial, and the failure to obtain such inspection may tend to unreasonably delay the trial. The Commonwealth expects to introduce the records at trial as evidence of the charges against the defendant, so that means in the case in chief. Furthermore, the defendant is entitled to review these records in their entirety. This is going to take some time. This may actually result in a delay. A part of the Commonwealth's consideration to assent to the defendant's request for a short delay in trial is part of due to the plethora of new information revealed to a national audience. This is extremely relevant to the material that the defendant's criminal intent conduct. Yeah. So, and then there's also an affidavit. I think there might have to be a delay for this. It's such important evidence, and it's so crucial to the state's case. Now, I'm waiting for this document to go up. I'm going to try to wait for a few minutes. I ended up going for 3.5 hours today. I did not mean to, but it just happened that way, and that is just sometimes how it is. And if I can get access to the defense witness list, I will do just that. Sometimes Christina Rex comes through. But if I can, I'll just write up the post afterwards. I'm very interested to see. The defense sometimes puts ridiculous people on their witness list for no reason. So I'm interested to see if we're going down that road again or if there's something actually substantive. Oh, wow. Cambridge City Councilor Paul Toner is now facing a state charge for allegedly being a client of the Cambridge brothel that was busted by the government. I didn't know that. He wasn't at the, he wasn't at the probable cause hearing. I guess they're continuing to charge more people. Does no one have this defense witness list? Don't you all work on Friday afternoons? Come on now. Nope, it's literally just 2 posts. Anything? Somebody reply with the witness list? Dee Dee says she's working on it. Team Docket Rocket Stars. So I'll stay with you for like a few minutes to see if Dee Dee is able to get this defense witness list. She's normally able to get it up pretty quickly, and then we'll review it. Sometimes some of the other accounts also grab these files, but the difficult part is it's right at the close of court. Nothing yet. Come on, folks. It's a team effort. But the other thing is sometimes I'll be like, oh, it's not going to be that important, and then they end up dropping something that's like actually important. Yes, but there's a video where apparently Aidan Kearney said that he was like there was an option to flip on Karen Reed. Or is that what he said in the clip I had? Let me see.
Proctor, but belonged to Michael Proctor, but I'm just throwing this out there. Maybe somebody messaged me and said, can you run the plates for me just to make sure that those belong to Michael Proctor and Jen McCabe? Can you do that just to verify? Sure. But I was going to, it's not, it doesn't hurt to like dot your I's and cross your T's, right? So I want to verify that it's them, and I can just make a post like that. I do it all the time. And I say, can anybody verify that this, tell me who this car belongs to? Truth will set you free. Now, I didn't even know what her address was. Luckily, someone sent me her address. Someone sent me her address.
Oh my God. I get the implications there. Karen Reed got the addresses of all the witnesses in the discovery. Oh, that's quite an admission from TurtleBoy. So I got that clip saved. Where is this witness list, though? Very rarely do we... Oh. Here, oh, so no witness list. Oh, the jury questionnaire. Thank you, Dee Dee. I appreciate you for posting this. This is important. We're going to take a look at the jury questionnaire. And then it's, as I told you, this is an expanded jury questionnaire. And the reason why is the state asked for a second page pursuant to the Chisholm decision. So I'm gonna be able to. I'm actually gonna do this in real time. I work so hard. Like, I don't know if you all appreciate. I don't like outright and say it, but like what I have to do is when the files don't come from the court, we have to. They're not PDFs, and so people just, and it's very helpful, but people just release the files as screenshots, so one page at a time. Then what I have to do is I take the file, and if I don't actually get the document from the court by hand, I'll just take the file, I won't put any watermarks on it, and then I render it into a PDF. So that's what I'm doing right now. I took and since Dee Dee was the first one to upload it, what I'll do is I'll reshare Dee Dee's post when I compile this. But I have to take the images, which aren't really, like, they're great quality, but they don't download as you would need it for a PDF. So I have to render it as a PDF, make sure all the text is captured as accurately reflected in the source image. I don't cut anything off. Then I have to make sure it's all centered. Then I have to render it as a PDF. It doesn't actually come named, so I have to name it. Then I have to upload it, and then I have to promulgate it. And I do this for all of the documents. A lot of those PDFs you find, some of them we get from the court, but a lot of them are just me taking the images and rendering PDFs in like 30 seconds and then uploading them. All right, so here we go. And then I will call this Karen Reed Retrial Questionnaire. Jury questions document. I'm not spelling questionnaire. Just calling it the jury questions document. Alright, so let's see. Where's my... It's not over here, is it? Now I gotta actually upload this thing, and then we will look at the jury questionnaire together. I guess I could, if I wanted to be so inclined, put the jury questionnaire on the screen, which I suppose I will do for you all. I am a friendly little towel after all, so let's just see if I can make this thing appear out of nowhere. Hey, look at that. All right, I'm going to have to do some zooming here. Give me a second. All right, so you can see the first 8 questions, and then let me finish up this ridiculously long, complex process to get this shared, and then we will read it together, and then we'll see if we get a witness list. I don't think we're going to, and if we don't, we'll be done. But yes, you can take some time while I'm putting together this information to take a look on your screen. You can see the first page of the Karen Reed jury questionnaire, and you can go ahead and take your time as you read through that. All right, got the link. Give me 1 second here. All right, let me type this up for you. Here is the Karen Reed retrial jury questionnaire in full, including the new 3rd page regarding outside influence and media coverage of the trial. Full PDF. All right, that's all set. Thank you very much for your patience. Well, maybe I spoke a little too soon. It was all set, but I still had a little bit more work to do. I get frustrated. I don't mind if people take documents that I share, but I get frustrated when they take my actual journalism and then crop it. So I put a lot of watermarks on my work now, and you can all thank a certain number of people who should not have tried to steal my copyrighted content for why that happens. And I think the other thing that is annoying sometimes about processing all these documents is if I don't remember to put like the dates on the descriptions and all that, it's hard to, in like historical context, go back and trace when things were released. So in the moment, like I'm more thinking about archiving this material for the future, and so that's difficult. One sec. All right, there you go. Thank you very much for your indulgence there as I put that together. It's actually like this complex multi-step process to render and deal with all this stuff, which is, I mean, I guess I take it for granted because I just do it all the time. But it actually does require a decent amount of like skill. It becomes second nature after a while, but if you don't know what you're doing, I can see how people would get very confused. All right. So let me just deal with this. And then I apologize for you all having to stick with me as I go through the drafting process for this, but I want to make sure I give Dee Dee her credit. So I had to go find Dee Dee's post and reshare it. All right. And done. All right, so you all have probably taken enough time to look at those questions. Why don't you take a look at the next questions? Yep, keep enjoying reading that. I gotta, as much as I enjoy, oh, I hope I didn't forget to share my stream. I meant to share my stream in one of the Facebook groups. I might have forgot to do so. Sorry if I forgot to do so. But yeah, I do try to share these documents as well. And not only render them. So I'm giving you all some time to do some reading. These are just literally hitting the docket now, so. All right, there we go. Now, let's come back. All right, so these were the questions from the first trial. Let me expand it a little bit. So you can see these are all kind of the traditional questions. And then this is the new page. Do you have any knowledge of this case game from any source? What is your source of the knowledge? Television, radio, newspapers, magazine, Twitter, X, social media, Facebook, Twitter isn't social media, Facebook, Instagram, TikTok, other, podcast, family, friends, observations in the community, overheard discussions, other. What are the details of the case you're able to recall? Are you aware of any specific impact this criminal allegation has had on your community? What is your primary source of news and information? How often do you read print or online newspapers, magazine, blogs, and what sources? How often are you exposed to news from radio, television, podcast, or social media, and what sources? What is your familiarity with the case prior to today? Have you had discussions about this case prior to today? Is there any reason you would be unable to follow an instruction that during your jury service you may not read any news or media accounts about this case, watch or listen to any media or news broadcasts or commentary about this case, discuss this case with anyone, research or look this case up on the internet, or perform independent research? Is there any reason you would be unable to follow an instruction that during your jury service you may not read or view any social media articles, posts, videos, podcasts, or other non-traditional media platform that may discuss this case. Is there any reason, if you are inadvertently exposed to extrajudicial influence or media about this case, you would be unable to follow an instruction that you must report an exposure to a court officer? So that all seems pretty normal. That's definitely going to result in a very long voir dire process. It's going to take days and days and days, probably weeks. Looks like we don't have the state's witness list, though, so it looks like it's not going to be revealed. I know the witness list, unfortunately, is just not that's hilarious. I guess Mike Crawford got interviewed, the dog walker, but his clip wasn't included in the ID documentary. All right, no Karen Reed witness list. All right, folks, I read for you as much as I could. I'm extremely tired. We've gone for 4 hours. Thank you so much for being here. Let me check a few of the comments. That's how I like to end the stream, keeping with my tradition of having gone for hours and hours and hours. Let's see. I don't even remember where we left off. There's way too many comments, so I'm just going to jump in randomly. People said it was heartbreaking every time seeing Peggy and Paul. I agree. Yep. How did KR's lawyers reconcile John O'Keefe having a fight and no dog DNA exactly, or male or DNA anywhere exactly? Defense has just docketed amended witness list. Thank you. Yes, Trevor, we're looking for it. Judge Canoni annoys me. I don't think she's weak. She's impartial. It doesn't matter what the defense puts on their list. Hank's list is gold. I agree. The like button, have you hit it today? Oh, yes, please do leave a like and subscribe if you're new to the YouTube. I do most of my streams and writing on Twitter and things like that. But you can actually, I have a Buy Me a Coffee, buymeacoffee.com/Grant Smith Ellis. I don't think I publish there. I have patreon.com/Grant Smith Ellis, where I publish some work. Facebook, Instagram, Twitter, all same handle. Most of my content is on X. You can find a pretty good archive there. But if you're new to the YouTube, feel free to subscribe. I'll try to do more streams here. Liking the stream and apparently subscribing from the video is actually helpful, so please do if you can. Thank you, as always, to Maui Swift, who does this moderating single-handedly. I'm very grateful for Maui Swift's help, and please give them a round of applause and make sure to say thank you. Without them, this would be very difficult. Folks are saying they woke up feeling excited. Amber M says, Grant, I've been here with you, and I can't stop with this trial. It is an experience. I didn't think I could watch a second trial, says Jew Drops, and then they say, but bring it on. Mr. My King of Kings says, Amber, saying it's like an obsession. I was so vested in the last trial, I didn't think I could do it again. Wow, oh my God. Reed smirking. Couldn't watch it if it was just Lally again, but since Brennan took over, I can't wait for trial. I say that I'd probably still watch even if it was just Lally, but I wouldn't be as excited. I think Hank Brennan has a more deep knowledge of like the federal system, and that's why it's so much more intriguing to watch this time. Lally was good, but went on and on, and Hank Brennan is directly to the point. I really respect Lally. He seems like a very level-headed man, a gentleman really, but he's too nice for the defense team. Yep. Hank is a gentleman too, but he has a killer instinct. He's a fighter. Yeah, and he's rattled after I would say Hank's not rattled. He's vengeful after the stunt the defense pulled yesterday. I think Adam Lally had health issues. His neck was bright red, but he put this whole case together. Just needed Hank Brennan to bring it home. Yep. Judge let Jackson get away with so much last trial. Yep. Number 15 is a compound question. Should be rewarded. Let's check number 15. Was that up here? Has anyone close to you ever been involved in an incident involving drinking and driving? If so, would that experience prevent you from being fair? Yeah, I guess probably that is compound. Good point. Thank you, Grant. Great job, Grant. Thanks, Grant. That was from Rita, Lisa, and Maui Swift. Amber Ann, thank you, Grant. Thank you, Grant. Great coverage. Thank you all. Goodbye, folks. Lisa Cox, thank you. You're great, Grant. Heard from you about Roberta Glass. Keep up the good work. Yes, thank you, Roberta. Please check out Roberta's channel, too. She does a lot of great coverage. And she highlighted my butt slap video, which was a great example of Alan Jackson trying to mislead the court, and then Hank Brennan referring to material in real time to call out Alan Jackson. Thank you, Maui, as of course. Thank you for Lisa saying this is a great channel. And thanks to everyone who joined today. I'll see you soon. I got to go. It was 4 hours again. I'm tired. I hope you're not tired. Enjoy your Friday. If we get the defense witness list, I'll try to follow up with you. And if not, I'll maybe see you again for a stream this weekend. All right. God bless. I appreciate you all. From this towel to you, enjoy the rest of your afternoon. It's almost 5 p.m. Thanks for being with me, folks. My name's Grant Smith.